petitioner SAG has been seized by the police, my lord.
Sorry.
TRLMC
What do you
29991
want?
by 2022. The account of the petitioner, my lord, SGG has been seized by the police, my
Give-
lord.
I may be pardoned to make a mention, my lord.
Yes, madam.
My lord, there's a CRLMC 1605 of 2023, my lord. It was supposed to be taken up, a specific date was mentioned by your lordship, but somehow it was not come. It's urgent, my lord. 22nd with special judge re achi he is not allowing much of time. So if your
what-
lordship,
It's for what? Before trial court?
it's for quashing. It's for quashing, my lord.
No, what is happening in the trial court?
The trial court, your lordship has given order to take time in the trial court, but the trial court is now is like ki,
I know, but what is happening there? What is the stage?
Cognizance na bakwachi, my lord.
Cognizance. So take it.
My lord,
Yes.
restoration matter.
Anything? Yes.
Can you mention from the list item 1 to 5?
Item 4, lordship, pray for an adjournment.
4, huh?
4.
The request of counsel for this. 3. Okay. Compromise. What do you want? Compromise matter, why are you seeking your phone? Okay. Sorted. Yes.
Item 6 to 13.
Item 12, lordship, pray for an adjournment.
So why are you asking adjournment in all matters?
Lordship, some more documents have to be collected.
On the request of current counsel for this next time, huh? Yes.
Item 13, mediation fixed to 21.
21 for again, that is mediation process is still going on. Again.
Item 14 to 27. 28 to 36. 37 to 42.
My lord, item 37, withdraw.
Withdraw?
Yeah.
Yes.
Item 43 to 48. 49 to 53. 54 to 62. 63 to 68. 69 to 77. 78 to 86. 87. Item 1.
Yes, sir.
In this case, also the petitioner challenged the Cognizance order
Use
dated.
my phone. Yes.
Cognizance order dated 12/8/2019, lordship.
Yes.
Well,
2019 is the cognizance order. Now what is happening?
lordship, still it is in
Charge has been
that.
framed.
No, lordship,
Only
not from
cognizance.
lordship. Charge sheet has, police has, charge sheet has been filed, lordship. Insufficient evidence, lordship, that is a false case. But despite that, lordship, the honorable court, lordship, special court, lordship, taken cognizance. That is page 53, lordship.
53.
3.
Okay.
Operating part is 54.
Huh?
Operating part is 54.
54. 54. Yes. Yes. Read it.
Lordship, relevant person, lordship. The IO has submitted the charge sheet as insufficient evidence, even though the case has been registered under section 294/506 of IPC, read with section 31R 31S of ST professional pension.
It's all right, but
Lordship.
it doesn't, the IO files a closure report doesn't mean that the trial court
No,
can't take
lordship.
cognizance. Let us see 161.
Lordship, my part
Let
is,
us
lordship, there is no any such independent.
See, the IO is not the person who is
No,
giving the
lordship,
judgment.
I am not on that part, lordship.
Let us see the evidence is there or
Lordship,
not.
what happened, lordship? all are interested witness, Lordship. The occurrence take place.
Whether they are interested or not, that will be decided in the
Well,
right time. Whether any
everybody-
evidence is there or not, who is the IO to say that they are interested witness? If
Uh,
they are
let's-
interested witness, why has he recorded
As-
statement?
As because they have, Lordship, what happened, Lordship,
Everybody is
actually,
stated in spite
The-
of that.
no, actually, Lordship, what happened,
Let us
Lordship,
see one
dispute, dispute regarding Lordship Panchayat, mane,
Maybe let us see what are the
Lordship.
evidence which has come on record. Let us see.
all are
You
interested,
are
Lordship.
Kumar Pradhan.
Who are came to Tahsil office, Lordship, all are due, as because notice has been issued to the present petitioner as well as the other opposite party, Lordship. They appear before the Tahsildar, Lordship. So has have notice has been issued, Lordship. So after, as because it is not settled in office, Tahsil office, thereafter they have assaulted me, Lordship. I have lost the affair, Lordship, and only to counter the affair, Lordship, they have lost.
But how will you get out of page 31, 32,
Lordship.
33,
34.
34,
Lordship.
35, all statements?
Lordship, all are villagers of Bank Circle, Lordship, and they came to the Tahsil office. In the Tahsil office is matlab area of market area, Lordship. They allege that, but there is no any independent witness, Lordship.
Problem is
Dokan गुड़ाक अच्छी सबू अच्छी.
may be correct, but how to get out of the 161 statement? The IO is completely wrong saying that no evidence. He collected evidence, filed it, and thereafter he says that.
The statement of the informal, Lordship, all are.
I just simply issue notice. I will
Last.
not say anything. Simply issue notice. You
Last.
can settle, you settle.
Lordship.
That's the only way. Otherwise, you
Last.
don't have it. I'll have to discuss.
Probably it is settled, Lordship, as because counter case.
Maybe that's the reason I'm issuing.
ଆଜ୍ଞା ତାଙ୍କ କେସ୍ ଟା ଯେହେତୁ ଚାଲିଲାଣି ହେଇପାରେ.
No, settle କର।
Lordship, Lordship,
କିଛି ରହିବନି। I'll simply issue notice.
Lordship.
Yes.
Item 2,
ଗଲା ଡେଟ୍ ବି ଆସିନଥିଲା.
None appeared. What is this matrix by the way?
Metro my lord, his software, your lordship may kindly see the list my lord.
Uh-huh.
Why two cases he has filed,
Uh-huh.
he has not mentioned. Perhaps for that reason he is not coming, my lord. First he was asked for time, and thereafter my lord he has
He has already filed.
already, your lordship may kindly see the copy of order dated of CRLMC order dated at may kindly be seen.
Copy of yes. He is not disclosing.
He has not disclosed the matter out of which present criminal miscase has not
Right.
been.
Earlier, the present petitioner, none appear for the present petitioner. On the last date of hearing, or nay, on 21/6/2024, a request was made on behalf of the petitioner for an adjournment. The matter was adjourned to 6/2/2025. None appeared for the petitioner on 6/2/2025. Even today, none appears for the petitioner. It appears that the petitioner had earlier approached this court by filing two different petitions, namely CRLMC 1521 of 21, which was disposed of on 21/12/2021. Again, he filed CRLMC number 450 of 2023, which was disposed of on 2/2/2023. Regarding the said petition, nothing is disclosed in the case. And none appears for the petitioner, hence the petition. is
Previous date
dismissed.
also.
Huh?
Previous date also got brought.
Hence the petition is dismissed. Yes.
item 5,
To file a affidavit regarding the same, my lordship, we have already filed, my lordship. That is in the record, my lordship.
What affidavit?
Regarding the same, my lordship,
The loss of the same, my lords, the CRLMP application
Yes,
is just
yes,
filed.
Here in this case, my lord, that is Bharatpur case, my lord. The lordship shall say the mobile was seized by the police. Your lordship, he has claimed that in the mobile, my lord, there is a SIM card.
Hmm.
But the fact remains that SIM card was not there in the, as per the IO, my lord, there is no SIM card. He has filed a PIDMIS case for release of that SIM card. Your lordship has called for the IO previous date. And he has stated that there is no SIM card. But for that reason, your lordship is directed to file an affidavit.
Yes.
On that basis, we have already filed the affidavit, my lord. That is on the record. But that is in the CRL MP number 1493 of 2024.
1493
The last
93
matter,
of 2020.
you file the affidavit. Yes.
like a file.
You got the affidavit.
My lords, I just received the affidavit, my lords. If my lordship rightly remembers on the
Where is that affidavit?
There is my lord,
Affidavit dated
affidavit dated
9/4/2025, my lords.
9/4/2020. 25.
affidavit is not there.
That is in CRL MP number 1493.
1493 only I am there.
My lords, it's not
1493.
in 1493, my lords, it hasn't been, there is no noting in regards to the affidavit. In the CRLMC, the first matter, my lords, there is a noting that no such affidavit has been filed by the IO regarding missing SIM card. So that hasn't been brought on record.
In fact, you have to file in the first petition. You file the first petition.
File.
Huh? The affidavit stated, affidavit pursuant to the order dated 23/2025 is stated to have already been filed, but the same is not on record. The registry is directed to locate place it on record. In the meantime, the opposite party may also file the affidavit in the connected matters. Okay? Lease the matter after 2 weeks, 3 weeks.
Item 6,
After 3 weeks. Okay. Yes.
item 6,
Six.
Okay, lordship, say.
Password. Yes.
item 7,
Item 7, I will passwords.
Password.
As in item 7, Mr. Pandey is entering appearance today in 7 as well as 79. There are two connected matters.
First is conduct, entered
Um,
appearance on behalf of the petitioner.
No, on behalf of the opposite party number
Opposite
2,
Party number
private
two.
opposite.
Why
party.
is it held?
The government. And 6, file for whatever now you take on record. The 6,
Let's say if we have filed a memo of appearance.
memo of appearance. Record. The 6, 2 weeks time to file the response to the petition. Leaves the matter of.
Let's here, there is no response required because your lordship had sent it for mediation. Now it will be finally heard. If your lordship may fix up a date,
Response, if any, to be filed, let it, file. Leaves the matter.
Let's say interim order continue.
7 and
7 and 79. Interim order continue.
In both the matters, mediation failed.
That's
Or
right.
the matter that was sent for mediation. Or it will be for unsatisfactory. Leaves the matter for you. Yes.
Let's say interim order there isn't. Okay,
Yes.
that's
item 8,
Password.
item 9,
May I please?
Yes. Yes. sir.
Last instruction, charge sheet submit করে দিয়েছি।
Yes. What are you seeking here?
There is no kind of phase 9 is the prayer.
Huh?
Phase 9 is the prayer.
Yes, I think that's for that one thing.
Two your lordship, you can prayer to the honorable court may direct to the court below to finalize the matter with the different.
মানে কপি করছিল
Sorry?
স্কোয়াশ করে আমি রিকোয়েস্ট করছো ম্যাডাম
But see your prayer, you what are you asking?
Our prayer is to.
Stipulated period. নাহলে আগে রেফার
When was the FIR?
সিজ করছেন মোবাইল সিজ জোড়া আগে
Yes, what are the grounds? It's not routine petition. The FIR is filed, then you file for quashing. You have to make out a ground. You're not prepared. Let a counsel for the petitioner seeks an adjournment because he is not prepared with you. Leaves the matter 4 weeks. Prepare and come. Yes.
জেরক্স করে মোবাইল
Sorry? Each from. So recent password. Yes. 8, yes.
6 not.
Item 6 not placed.
Item 6 not press out. Item 6 not press कर दियो. Item 8 कौन है जी?
Item 8 bail reject.
Anticipate bail agent reject.
Although the petitioner is seeking question of the FIR number also, return under section so, however, he submits that he would not press this petition. Rather reserve the right to agitate the issue at the appropriate stage before the trial court. Then consequently, the petitioner further submits that he has approached this court for grant of bail in this anticipated bail or bail?
Anticipated.
Bail. Not mentioned also. Anticipated bail by moving ABPL number. Give me the number. On that ground, I can dismiss it, but
141,750
141,750 also, which has been dismissed on
12/1/2024.
12/1.
12/1/2024.
12/1.
More order than कुछ first or second.
Already there is an order.
That has been dismissed.
Only dismissed.
All this.
Dismissed on
12/1/24.
hence he submits that he submits on the instruction of his client that the petitioner would be appearing before the court on or before 30th of April and resort to the remedy available to him under law and him under law. It is open for the petitioner to move for bail move application for grant of regular bail on all the grounds as has been urged in this petition and any other ground available to him. If such application is moved on surrendering before the court below, the same shall be considered by the courts below. Courts below on the same day. Yes.
By maintaining the principle of parity. By maintaining the principle of parity. So another reason.
Sorry, I didn't follow.
Principle of parity.
Including the ground of parity. All the grounds I have said, including the yes, no problem. Yes.
And 10.
The informant the principal of the Bhadrakal on 11/4/99 he filed an FIR against the one student of +3 students. He was expelled and the students, college student, they have destroyed the in the college and destroyed some college.
Who are you?
They said in the FIR page 16, I am one of the leaders. See the last 2 lines above.
Yes.
Behind the screen and instigated them among the mob Vibhudatta Mahapatra, Ramachandra Malik, Pitambar Malik, Bhagirathi Sethi have taken the leadership when I identified. Well, other 3 that the leaders, as per their information, they have filed the CRLMC and this on the court. They have quashed the cognizance. See for the moment page 22. 22. The court below is mentioned in the order sheet as 27/6/2002. The order passed in CRLMC number 1439 of 2002.
Have you got it? Got the order of?
No, he has mentioned.
You could have got it. You get it. The numbers are there from download to copy. You get it. I'll pass it over. Get those order.
Your lordship may kindly see this.
Yes.
Prayer, your lordship may kindly see page 8.
Yes.
From both sides, was the impugned order of NPW dated as filed in GR case number 1.
Then I'll cancel the NVW, go and appear and tell whatever you
Then
want.
your lordship may kindly see.
If you impugned order by
Ticket.
you already 11/1/2002.
He has not mentioned that earlier 3 applications have been filed, but nothing has been mentioned in the.
I will cancel the NVW, you go and appear and.
No, I am on the bell. I am on the bell.
You are asking NVW.
But the order must see for the moment that the NBW by mistake is mentioned.
Another petition is also pending.
But see for
332.
see for the moment annexed
You tell
to.
me how many petitions you have already filed and how many.
I have not filed a single. This is
He is saying.
no other leaders. They have filed and this on the court has quashed the.
Senior is also conducting counsel.
You have filed yourself.
But
Pitambar Malik.
yes, I have filed the NBW. Now you filed the ancillary bill. This on the court
No,
has.
no, CRLMC you have filed.
That is pending. That is for NBW. That is for NBW.
Lease this matter along with.
NBW I have not
One
pressed
minute.
because he is already on the bell.
Lease this matter along with CRLMC 3322 of 2024.
And also, my lord, mentioned the order sheet. That is 1439 of 2.
No, no, that the order you have to get it.
But this on the court is
No, no, you get it. Release it. Huh? These two.
they come tomorrow.
Not tomorrow. You should have come with the order. See,
Yes.
3 names are taken in the FIR.
Yes,
You say that
not a fair in the order sheet. The court below they have
in
mentioned.
the FIR also have three names at the end.
Yes, yes,
You say that quash these other two people, it has been quashed,
yes,
which is reflecting in the impugn order.
yes.
Get that order at least.
I go tomorrow. I will.
Also, and also,
Come
not the prayer, my lord, only the prayer is
The
amendment.
prayer also you change. What is this prayer?
That by mistake it is mentioned the
By
NPW.
mistake only he is pointing out. The mistake only corrected. Always mistake has to be corrected.
Yes, I will file it. You come on tomorrow, I will file the.
Not tomorrow. You should have come with all these things and after 1 week. Yeah?
One. Again, the Friday, my lord.
See, what is this? You file a petition, you don't have an excess.
Today I
And
have.
you ask the court to collect it.
No, no, I have prayed. My,
Sab will be after.
no, I have prayed, my lord.
This-
Because
this
if my lord,
don't-
it will be easy for the court to.
2 orders you are referring.
Yes,
Where
I
are those orders?
I will come with it tomorrow, my lord. To come to.
Not tomorrow. I can't.
Day after tomorrow.
Next week. Huh? Yes, next.
11.
Present petitioners in the challenging the order of the question.
Quashing.
Right.
Yes.
The under answer for present petitioners, both he as they are the leader, one is principal. Allegation is the informant has filed a laws affair under answer 1 with even misbehavior in the college office.
Hmm.
Thereafter, the investigation was done and no footage, TV footage are taken into consideration, and absolutely there was no
No, it's the only cognizance taken.
cognizance taken.
Let us see what are the allegations. again.
Allegations to lordship, I see answer 1. Here, allegation that he has used some unparliamentary language, principal.
Come to page 24.
My That's it. TV footage there, that is not there. Because of the previous animosity, this is. All are the leaders.
Yes.
My lord, S25.
Yes.
It is not come. 5 lines for job manner. He found Professor Bernard South, examination in there, Professor and Clark also present there on his arrival. Suddenly, at the instigation of the principal Gopal Chandra, were all have been my lord, sir, filed this petition for washing. Gopal Kumar Clark, Bernard South and Mr. Kothal told him to loud voice as to why he complained before the principal on 25/2023 about shortage of invigilators and Bholanatha Bera and Girish Chandra Kothal flooded him in obscene language and threatened with their consequence. So offense is under section 1, the cognizance has been taken to 341, 320.
Cognizance is not wrong. Cognizance is not. Yes. What are the grounds? Cognizance is not wrong.
Well, lordship, CCTV is very much available in the college, my lord. That has not been taken into consideration.
But there are some material
That
cognizance.
affected the pre-
Argue and charge. Argue and charge.
There is, well, lordship, because all the, because of the pendants of this case, my lord, the present petitioners, they have retired.
But see, their conduct also has to be seen. They argue at the stage of charge, I will give a specific direction. for passing a speaking order.
Lordship, there is
The
possibility of
petitioner is
lordship.
agreed by.
There is
Petitioner-
possibility of, Imagine lordship.
They bring them, I'll pass it.
Your lordship will issue.
Then you will say that court has issued notice, come and. I just simply, what I do
Because
is,
your lordship can visualize, they are the.
I understand,
highly
it.
educated.
I understand, I very well understand. What I'll do is, I'll put it next week. You persuade them and bring them, so that I'll finish that here. I simply then next week, and you persuade them and
Your
bring them.
lordship will kindly visualize. Because of the principal petition number 1, he has directed the office matter to that you are not conducting your duty proper matter. That is why.
But all these, they are
Your lordship-
professors, they are professors, teachers, principals. If they do like this, see, there is, they shouldn't indulge in all this.
No,
Anyway, you can bring them. You bring the informant. Tell them to sit together and
Well, I will take instruction.
next week. Next week.
I-
Try. And these kind of disputes has to be resolved at the very threshold. And it is not desirable that the principal, teacher and everybody should go to this court and stand there.
You are a educated person.
যাহা হয়ে গেলে বর্তমানে কোথায় যান কোথায় সেটা নেক্সট উইক
10 days after. 10 days after.
না 10 days after.
Item 14.
Item 13.
My lord, item 14, my lord. I mean VC, my lord. I
Yes.
am praying for an short adjournment, my lord, and taken up next
Why?
week candidate. And my learned senior is just out of station, so he will argue in this matter. That's why I am praying.
Round of non-availability of the arguing counsel on behalf of the petitioner and adjournment is not, leaves the matter after 4 weeks.
Obliged, obliged.
Your lordship, item 13, interim order to continue.
Please, your lordship, my lords.
15 your lordship, and last 8th that matter is listed for this only 4 your lordship.
Lordship are directed for specific instructions.
Regarding
matter.
call for the 164 statement of the victim, your lordship. Sambalpur is the Ramyo Pendi law decision. Next week also, in the meantime, I will
Okay,
correct the one.
on behalf of the state council, a request is made for an adjournment to obtain the case diary and statement of the victim under section 164. The matter after a week or 2 weeks.
16.
Let's, may I pray one thing, till then if adjournment
No,
application.
last time I have.
Grateful.
16.
Petitioners challenges the order of revision before the learned district judge only on ground to release the vehicle at the ground that the pendency of the confiscation proceeding, the order cannot be. Only I pray your lordship that vehicle was seized in 2024. Now annexure shows the present petitioner is suffering from cancer. Only speedy disposal of the confiscation proceeding, that is. Because at time
No,
of
No, no.
pending of confiscation proceeding, the
You are entitled for interim release, interim jama.
no,
You are entitled. Why?
My learned senior is praying for early disposal of the confiscation proceeding pending for the authority of lordship. I have no objection to that respect, lordship. So far 72 is.
But he
Yes,
is entitled to a better release.
Yes, that's.
Therefore, I'm saying.
Your lordship, that your lordship.
Cancer
Judgment,
patient.
your lordship, last week, your lordship, Lakshmana Srinivas, Republic of India, your lordship. That is, you have categorically mentioned the guidelines, your lordship.
Read that
Yes.
judgment. I have formulated the guidelines. Also.
Yes, your that.
Yes, there is a
Just change, if you want to read it. I'll just put it next week.
yes, lordship.
Read that judgment.
Yes, your lordship. Just.
I have given a guideline how to deal with this kind of situation.
Yes, your lordship. That I have. Past where I have no.
What I'll do is,
Yes.
I will set aside the imbue order and send him back to the trial court to decide in light.
In view of the judgment, fast, your lordship.
Yes,
Lordship, good debate.
The petitioner is agreed by the order dated 23/9/2024 passed by the district administration judge in criminal division 21 of 2024, whereby the order of learned STJM Jajpur in criminal case number 119 of 2024 has been affirmed. Has been affirmed. The
Yes, yes.
SDJM has passed in your favor?
Yes, no,
Confirmed judgment. It has been affirmed. Affirmed. The petitioner had moved an application for release of the which vehicle is this?
Bolero pickup goods carrier.
Bolero pickup goods carrier seized in connection with the FIR number, connection with FIR Bari PS case number 358 of 2024 under section 457 of CRBC. Land Council for the petitioner seeks to withdraw this petition to file a press petition in view of the recent judgment of this court passed in the election. Liberty is granted to the petitioner to move a press substitution from the trial court, relying upon the judgment of this court in if such application is same shall be considered within a period of 15 days. Yes, with this observation, petition is put up. Yes.
78.
Take that judgment and next. Yes.
70. May I please, Your Lordship? Here, the present petitioner is challenging the initiation of the domestic violence proceeding, Your Lordships. The petitioner happens to be the son of the opposite party. Now, the mother has filed the application.
Petitioner is the son of
Opposite the complainant. The mother, the son, along with husband.
Now, what is the relationship between Nihar Agarwal?
Nihar Agarwal happens to be the son of Parul. My lord, the only allegation, mother and son, along with other family members like the husband and other in-laws are there. The petitioner has been implicated only for the incident. Your Lordship may see the paragraph 9 at page number 20. This is a stray incident for which the petitioner has been implicated. And
para 29.
Para 9, Your Lordship, page number 20. The complaint.
Yes.
That on a particular, the marriage between the parties.
Para 9.
Para 9, Your Lordship.
Read
It is pertinent to mention here that on dated so and so, when the agreed person was keeping the clothes of the respondent number 4, means the present petitioner here, in the Almirah, the respondent number 4 had thrown a punch to the aggrieved person's face and misbehaved with her. Thereafter, the in-laws came, started misbehaving.
Why have you implicated your mother?
No, mother has implicated me, my lord. Here, the present petitioner is the son. Before your lordships, 22-year son.
You do this thing to your mother.
My lord, after 23 years. Now, your lordship, I am coming to your lordship's query, your lordship. Why this allegation have been?
You mixed up with your wife and harassing your mother. That's the case.
My lord, I am the son.
You mixed up with your wife and harassing the mother. That's the case.
No, wife, my lord, the opposite party happens to be the mother. Parul is the mother. My lord. Here the mother is suffering from mental disorder. I have annexed all the documents, annexure 2. Since 2014, she is undergone treatment, my lord.
Yes.
Now the family dispute between the mother and the husband, means the father of the present petitioner, that has come to this ugly phase of, my lord, litigation. Only mediations, because this kind of very sensitive.
Notice.
My lord.
But your mother needs attention.
Yes. My lord, section 9 petition has already been filed by the.
You are dragging your mother to the court.
No.
You say that your mother is not well.
No. My lord, I am not dragging.
Medical attention, not to the court's attention.
Yes, your lordships. That is what the my lord think that she has not been given. She has not been given proper medical treatment because she is with in her parental house.
Why are you bringing her to court then?
My lord, the case is against me. She has filed.
Obviously, she will file.
And the
okay, issue notice. Take it. Take out notice after 1 week or so. Yes.
And your lordship may send the matter for mediation because the.
And straight away send it.
My
lord. Where is the? If she is not well, who will represent her? I don't know.
My lord, the mediator can also advise because she is in the custody of her parents, the lady, and she has not been given proper care. Section 9 we have filed.
Implicated the other parties also.
No, mother we have filed. She will come, and thereafter the mediation can, my lord, refer the.
Notice the present petition. The petitioner is the son of the good father. The dispute is arising out of a material discord. Therefore, the counsel for the petitioner believes that there is a chance of out of suit. Issue notice to opposite party. Also, the matter is referred to Bhubaneswar District Court.
The lady is staying at Kotak. I am staying at Bhubaneswar. Here, High Court mediation.
All stakeholders, of the case and exclude possibility of that. And meanwhile, the petitioner may move application before the trial court, or seeking an adjournment owing to the fact that the matter is referred to mediation.
Great.
Yes.
May I please your lordship? I am through VC madam. I have preferred this against the NBW issued during submission of charge sheet showing the present petitioner as a absconder madam.
Where is that order? Where is that order?
Order
Order?
3 to the 20 your lordship. 33,2020. 33,2020 your lordship. Page 14. Relevant page is 15 your lordship. Madam. In the meanwhile, the 76-2. Informant and the victim has got married, my lord. Page 14. There is a male child of 5 years.
1
And-
minute. 15, huh?
Yes, your lordship.
NBW issued.
Yes.
What is this
376-2N.
What is this case?
376-2N and 6 postco your lordship.
Let him go and appeal. Madam. Petition is agreed by the order dated 3/3/2023 passed by some special judge Foxo Sundargarh in a special GR number 15 of 2020, whereby NBW has been issued against the petitioner for his failure to appear before the court. On instruction, like yes, and till then the LBW issued by the impugn order dated 3/3/2022 state.
Village
You
man.
won't appear? Yes.
Village man.
Dispute.
Item
Yes.
19.
19, I just came before lordship for a final second up order. I was granted bail in ABLAPL 3607 of 25.
Give me that.
My lord, that copy is not.
Nowadays it is so easy to get a copy.
My lord,
Unless I see that, how can I do?
I was granted bail on the condition that the petitioner shall not have antecedents. These petitioner have some antecedent of similar nature. That is 379 and 21 of MMDR.
Then
I may pay first half, second half parity because other accused also.
give that order, please.
Right now.
I may not pass some order which against, I'll just pass it over. Just get that order so that it will be here. Right.
20.
Please. Ballot in the petitioner challenging the order date was obviously 2025 manner, where the petitioner is seeking recall the witness PW7, who is the father of the victim, and
PW,
PW
recall PW 17.
7, 8, and 17 manner. They are the victim, and my humble submission is that manner. The petitioner released on bail in the year 2020 manner. Thereafter.
Show me their evidences.
But Experience they residing at one group in one center manner. His wife and husband are having a child also.
Where is their evidences?
Madam, page number
32 is the PW7 evidential also.
separate marriage call during examination of the victim man.
2017.
Madam, PW 70, page number 46. In para 3 manner, he admitted that we stayed there 1 month as a husband and wife, and the accused had sexual intercourse with me. One day police arrived there with my father and rescued me.
Who is 17?
17 is the victim.
Victim man.
PW8 is the victim's mother. PW7 is the victim's father.
At present, the age of the victim is only 25 years.
Now they've settled.
Basically, but they were living the life as a wife and husband. In one. But that has been mentioned in the opposite part number 2, wife of Dr.
Where have you said that?
But the first title was Parati, opposite part number 2.
No, where is the age of the girl now? Where will I get?
During the time of deposition, madam, he was 17 years.
Fine.
In the year 2018, madam. September 2018.
17.
Madam.
Now it's a major.
Madam.
I'll just issue notice. 1 week after. Bring. Yes.
51.
My lord, without going to the merit of the case, my lord, this petition can be disposed of in the light of Annexure 5, who accused person similar situated.
Annexure 5, huh?
My lord,
What has happened? 5.
page 58, my lord.
And, one more thing is that
What
the
is-
same petitioner,
He's co-accused.
My lord. Similarly putting
Anirudh Mandal is
Anirudh
a
Mandal,
co-accused.
my lord.
also in this case, what happened, the present petitioner earlier approached this honorable court under section 438 for bail. This honorable court has fraction direction.
My lord.
Tufan Singh. Something. Yes, there is an order already.
My lord, Annexure 5 may be considered, my lord.
I'll consider, but what about this? You have already approached.
Yes, I have already approached. I have not suppressed, my lord. I have already mentioned in this petition.
Also the petitioner is seeking quashing of who? What are you seeking, by the way?
FIR.
Quashing of who? The FIR.
And Annexure 1.
Annexure 1 being Kosa Kumuda PS case number 92 of 2021. Registered for release commission of offense under section 20B 2C and 29 of NDPS Act. But the legal counsel for the petitioner submits that he would not press the petition, rather reserve the right to educate the issue before the trial court at the appropriate stage. And then counsel for the petitioner submits that earlier the petitioner had approached this court by filing ABPF number 1913 of 2022, which had been disallowed by this court by the order dated 8/3/2022. This court has also granted liberty to the petitioner to appear before the court within 4 weeks and move appropriate application for grant of bail, which was directed to be disposed of by expediency. The petitioner has not surrendered yet, rather moving present application. Then counsel for the petitioner, drawing my attention to the order dated. Where is that order? 5, na?
My lord, 4924.
Order dated 4/9/2024. Passed in CRLMC number 3265 of 2024 in regard to the in the case of the co-accused. Submits that the similar order may be passed. Regarding head to the submission made by the party, made by the petitioner, the application and the presentation of disclosure granting liberty to the petitioner to surrender before the court within a period of on or before 5th of May, and move and liberty is granted to move the application before the court below, but relying upon the judgment of Tufan Singh versus State of Tamil Nadu before the court. Such application is
One more thing, my lord, the principal accused already released on bail,
You take it.
my lord.
22.
Obligations.
The innocuous pair of petitioner is that here the pair is for early disposal of the 1/6 case. The 1/6 case is 2014. That's the check bounce case, not that now the 2014.
Who are you? You are the informant.
Yes, I'm the complainant. I have lost my money is there.
Petitioner has initiated 1CC case number 1186 of 2014.
Yes.
2014 against the opposite party. The petition was filed. When was the complaint filed? Complaint was
Complaint was
filed.
2014. Lord.
Date.
Yes, that is
Page annexure 1, page 9, you know.
11/8/2014.
Huh?
11/8/2014.
11/8.
Yes.
Um, 17, 7/2015 you filed. Just see the affidavit, para 13 affidavit. No, this is the affidavit. Okay.
Yes, sir.
Okay. 27/9/2014.
Page
Filed on 27/9/2014. The seal which has been effective 27. There is no date. No 27/9/2014. Petitioner being the informant being the chief submits that the case under section 130 initiated by him ought to have been concluded. The trial of the ought to have been concluded within a period of 6 months as per the section 143(2) of the since the proceeding before the court was prolonging since 2014, prolonging for about a decade. He seeks intelligence of this court for out the direction to the trial court for the trial. Therefore, once it's case number 1/6 of 140. Prayer made by the petitioner is in consonance with the statutory requirement, and so there's merit accordingly the trial court is directed to do and to see that the trial of the 160 case from control is concluded as it's not possible. Preferably within a period of 2 months. 2 months. The parties are also directed. The trial court shall not entertain the prayer of urgent to be each made by any of the parties. With this observation, petition is published. Yes.
23.
May I please your lord. The petitioner filed the LLC challenging the order dated 25/8/2022. That is
You will
under
argue after lunch, after having lunch. You will get some energy. You get some energy after lunch.
my lord.
Now it's speaking louder. Yes.
Challenging the order dated 25/8/2022 under Annexure 4, order of cognizance. Initially, FIR was registered against the present petitioner in an offence under section 341, 323, 294, 324, 506,
Yes,
307. Allegation against the present petitioner is that while the informant went to her cultivation field for sprinkling some cow dung, at that time the present petitioner, who is a relative of the informant, reached there and tried to assault by means of an axe. And due to assault, he was sustained some injury on his left side of the head.
What are the injuries?
Your lordship may kindly see Annexure 3, page 30, 31. Guruvari Munda is the victim informant. He has no sustained any injury, my lord. No external injury are available over the body.
Where are you reading? I'm not able to get.
Page 30, your lordship, and
30. Can you
inquiry
read
report
it?
is my learned friend is filed.
Can anybody read it there?
And the lastly, lordship, written,
No
external injuries are not found.
over the body.
Over the body, that has been mentioned in.
Oh, not over the body.
No external injuries are not found the body. That has been.
No.
Readable.
External injuries are
Not over the body.
Not over the body.
the body.
But weapon offense is acts.
My lord.
But that has been seized.
Intention. You had an intention.
No, my lord, in the FIR, as well as in the 161 statement, in the that was under Annex 2 series running page.
Okay, it's all right, but 307 is not made out. But what about the other
My
offense?
lord, I have only challenged the offense under 307.
Then at the stage of framing of charge, you argue. So this
My lord, with that observation, your lordship may dispose of.
petitioner has challenged the order dated 25/8/2022 passed by learned STJM bracket D in ST case number 26 of 2025, whereby cognizance of offences punishable under section 341, 323, 324, 307, 294 and 506 IPC have been taken against the petitioner. The learned counsel for the petitioner by taking it to the charge sheet and the documents form part of the charge sheet submits that the informant injured, alleged injured, has not received any injury as per the medical evidence. He has pointed out from the medical evidence the portion wherein it is observed that there is external injury in inverted commas. External injury over not external injury are not over the body inverted comma so on. On the basis of the same, he submits that on the basis of the said evidence, he submits that no case under section 307 IPC is fair out against him, as there is no injury sustained by any sustained by the informant of the alleged injured. Since the matter is at Cognizance stage, I am not inclined to over liberty granted to the petitioner to move for specific application from the urge this point before the trial court at the stage of bringing of charges. It is open for the petitioner to even move an application in that regard. With this observation, the petitioner will dispose of case.
24th.
May please, yes. This is the arrangement of complaint case, my lord. Petitioner filed this case, my lord, was the cognizance under section 138 Act, my lord. Under the amount involved, my lord, 58,404, my lord. Petitioners, I advise them ready to pay the amount when here at the court, my lord, the individual issued. Individual may state, my lord, short date, my lord, Manchester. Notice will go to Manchester, my lord. And
then what do you want? You will pay it and
they will pay, my lord.
Bring it. I'll put it next Tuesday.
But they notice, unless until notice go.
I'll issue notice also come with the draft and then close it here. Right now, 21st. Issue notice to opposite party. Also, this the matter on 21st.
I NBW that said that.
Till then, the NBW issued
16/5/2024.
NBW issued on 16/5.
16/5/24.
24 shall not be executed. Okay. Release the matter on 21st. Come with that.
What a mistake is it? The order that extend the type question while page 10. Cognizance dated 15/21 instead of 24. Wrong thing.
पैसा दे देले सब wrong खत्म
दे दो सिम
how it is wrong हो जात है कौन पर बोल दिया तो पास कर दो
draft दे दे
come with the draft
yes 25 is considered on the draft matter.
nobody is interested in the paperwork. Everybody is interested in their money.
Drafted money. Lord, the matter which I am
And that is the idea of litigation, adjudication.
That.
We are unnecessary.
The whole 38, 138 whole provision is, the idea is
to get money back.
That is the basic object.
Everybody is hiding behind the technical.
That's the reason all Supreme Court has laid down that guideline at the trial stage, initial stage, this is the amount you will have to pay.
This is Balkishan judgment.
In appellate stage, this is the amount.
Balkishan judgment.
That is the guiding factor.
That should be, the technicality should be kept aside and
Object is that one.
matter should be decided. Yes.
Not the matter which I am moving now, of course, not shocks my own conscience. This shocks my conscience. But I found that the petitioner here, there are 3 hotels involved in this Immoral Trafficking Act. Lord Chandan Lodge and Chandan Lodge, Nigama Nibas, and Hotel Divine. This is the allegation. The police report says that one Ranjulata Das and one Chandrakant Pujari, they have used a minor and her family in the Immoral Act. They have used it. First of all, one Chandan Lodge near Gundicha temple, they had taken on lease. They have used that. I am not concerned about Chandan Lodge. Now, second is Nigam Nivas. They had taken on lease for 10 days, used it for the prostitution purpose.
You are divine.
I am not there.
You are doing divine job.
I am divine. I am divine. I am the owner. In fact, my client had leased it out to.
You change the name, first of all.
That should be changed. I'll
What divine, divinity?
Yes, I definitely I'll advise, please change the name.
Because that doesn't befit you. The kind of
That
activity
doesn't
you are
befit the
in.
name at least, and your lordship will be surprised. Petitioner here is a Sebai of Lord Jagannath. Of course, what he has done is he has leased out this hotel.
Raghunath.
He is a Sebai, but he leased out one person, Damodar Pradhan. Allegation is
He must be owning it and might be
leased it out.
and
Yes.
those people might be.
So, so far as this hotel is concerned, those people, those incriminating people, they had taken for 1 day. One room was taken for 1 day, and that is how the name has come up. 1 day, report says that. Kindly see.
Where is that?
Page 21.
21.
Right. This is the report forming basis of the order. Page 21.
Yes.
On 11/12/25 night, Ranjulata Das forced the victim girl into Prosecution Hotel Divine at Sibo. After getting opportunity, victim girl only 1 day. They had taken this room without our knowledge, and this is how we have my hotel has come into the whole affairs. Now today, the executive magistrate has passed an order directing sealed this hotel for 3 years. If your lordship sees, section 18 power has been invoked of the Immoral Traffic Prohibition Act. Lord, I have only.
You are agreed by that order.
Lord, my hotel is sealed for 3 years. For 1 day lapse of the lessee, my hotel is sealed for 3 years. Now, if your lordship sees, section 18 power has been invoked here. Sir, copy.
18, huh?
Sir.
Yes.
Kindly see.
Closure of brothel.
It begins the like nomenclature, it begins closure of brothel and eviction of offenders from the premises. A magistrate may, on receipt of information from the police or otherwise, that in a house, room, place, or any portion thereof, within a distance of 200 meters from public, this is important, 200 meters from any public place, referred to in subsection 1 of section 7, is being run or used as a brothel by any person or being used by prostitutes for carrying on the trade, issue notice to the owner, lessor, landlord of such house, room, place, or portion, or agent of the owner, lessor, or landlord, or on the tenant, lessee, occupier of, or any other person in charge of such house, room, place, or portion to so called within 7 days of the receipt of notice as to why the same should not be attached for improper user thereof. And if after hearing the person concerned, the magistrate is satisfied that house, room, place, or portion is being used as brothel or for carrying on prostitution, then magistrate may pass orders. A. Directing eviction of the occupier within 7 days of the passing of the order from the house, room, place, or portion. B. Directing that before letting it out, during the period of 1 year, or in case where child or minor has been found in such house, room, place, portion, house during search under section 15, during period of 3 years, immediately after passing the order, the owner or lessor or landlord or agent or landlord shall obtain previous approval of the magistrate.
So what do you want to say? 3 years.
Sir, I say this whole, though it begins, the nomenclature is closure, but section 18 nowhere says, empowers them to seal it. Nowhere.
Closure, how will they ensure closure?
So at the top it is written closure, but below the entire provision is
The
read.
idea is to prevent. If
Yes,
so,
that's fine. That's fine. Even if going to the extreme that they can do that. But my point is, it is not used as a brothel. Definition under section 7, if you lordship see, they should have recorded.
It doesn't say that even one day it is used, it can be.
Sir,
treated
kind of see. Section 7 to Koila within 200 meters from a public place. My hotel is not within 200 meters of a public place. That's
You
satisfactory.
file a reply, let us see. You file a reply, I'll decide.
Right.
I'll
But
decide. Needs,
as an interim measure, I am not asking your lordship to stay it because it will amount to allowing the application at this stage. I will not make a prayer to that effect. Only as an interim measure, if your lordship will grant me a liberty in terms of the proviso, I will approach the authority to unseal it. Let them consider. That's all. Because one day someone was taken on rent, my hotel is sealed for 3 years.
But see what is the place? The place is
Right, Lord, I
so
understand.
important, the place for all of it.
It's if your
And
lordship
if
will
you do
private
like this, then
if your lordship will privately satisfied that it is used as
I'll decide the case. For all.
But I am
after
only
1 week, after 1 week.
I am praying.
You come with I'll decide it.
Let an observation be given. Liberty be granted to me. I approach them. That's all. Your lordship is not passing any order. I'll
No,
approach.
it's sub judice before this court. How can he pass any order?
They will consider in terms of proviso. Proviso is there.
So, you have challenged that order.
Right, Lord.
If I give you liberty,
Right, Lord.
yeah, how will you enter into the jurisdiction of this court?
No,
And decide it?
they may recall their own order also. That observation.
Then withdraw it and I'll
Withdrawing will not do.
withdraw it and I'll give that liberty.
Lord,
Withdraw
withdrawing.
and approach. Let it. I can't.
One
See,
time withdraw.
I can't say that I'll exercise jurisdiction. I'll adjudicate in the same time I'll delegate it.
As your lordship pleases, my lord, because I will not withdraw. I want the matter to be decided here.
Then I'm issuing notice. If you want that order, then I will.
No, I can't
withdraw
withdraw
and
because
let it-
my privacy grievance is my so-called has not been considered. My
18 has to be interpreted.
not only 18, there are 2-3 points.
18 vis-a-vis 7.
Vis-a-vis 7, that is 1. 2. I have given a so-cause. The statute mandates that my so-cause should be considered. Your lordship will see in the order, my so-cause has not been considered.
Then in merit too.
Right.
Yes.
And I am also not a person who is involved here. I have cancelled the lease. My lessee is in custody.
Have you placed the lease on record?
On record, it's there.
Yes,
It's
I have seen it. now.
It's there.
Yes,
It is already cancelled. It is already cancelled.
You are not accused.
Like, no, my owner is not an accused. Lessee is an accused.
He's a.
He is the accused. And your lordship on record will find that for one day, gote room se kiye bhada nala.
One day you got cut on that day. Nobody knows how many
There
days.
is no report. There is no report to that effect.
Incident when you
Sir,
will be. See, if the raid takes place, one day only raid takes place.
Sir, কিন্তু এই report রে যাহা কহিଛନ୍ତି, if your lordship will
Report
think-
one day only.
No,
Yes.
for Chandan and others, they have these two persons have taken on lease for this purpose. That is the report. But so far me is concerned, that's
But
not there.
On that day it was raided, but nobody knows you have been continuing
that's
in
based
that
on-
hotel. Things are going on. Nobody knows.
But that's conjecture
It
and
doesn't
surmise.
happen.
There is absolutely no history to that effect. Earlier also, there is no background of this hotel to that effect.
Let them file reply.
Right, Lord.
Let you file. You just see whether it was used for only
What's
one
the
day
background?
or what evidence you have taken. Whether
Yes.
anybody has said that this hotel is being used.
Or
this
previous
proper-
background of this hotel.
whatever.
Previously, যদি কেবে if this is used previously also,
Let them get that.
track record যদি কিছু থিব, let them get it. Lordship is fixing next
Meanwhile,
week.
change your name.
Lordship is,
You are no more divine now.
but I am divine, not they.
No, you are a client.
Yes,
I mean
yes.
you are client.
Yes,
no
Lord,
more
yes.
divine.
Yes. So, Lord, you are fixing up next week, my Lord,
Next week.
because it is sealed for 3 years. I will. Great.
26 in Parliament. From 19. It was passed over. I have collected the.
I'll take it up. Yes.
Please, your lordship, my lord. But here I have challenged the initiation of the entire proceeding pursuant to the FIR at Annexure 1. Basically on the grounds that on the same self facts, 1CC case which is at Annexure 2 was registered. With respect to the FIR, my lords may kindly have a glance to the FIR first. In the FIR, the informant has stated that she was working so-and-so and had given the petitioner, who was a businessman, carrying on real estate business in the name and style of so-and-so, and he had been known to him since last 24 years, 40 lakhs of rupees was given towards, which was transferred to the bank account on multiple dates towards a purchase of a flat, my lords. On the self-same allegation, my lords, in the year 2021, she had instituted an 1cc case. With regards to a check bounce case, if your lordship will kindly have a glance to page 14, annexure 2.
Why don't you pay the money you have taken?
My lords, the 1cc case is sub judice. The fact that the learned court below in the 1cc case did not take cognizance in 420 and it has issued cognizance in 138, 420 case has been instituted at the
420 is a
behest.
separate offense. That is a
Yes, my
statutory
lords,
offense and
in the year
138 has to go on.
2024, in the year 2024,
This is 420.
my lords, on the very fact, my lords, on the same set of fact, the
Maybe
magistrate
138
and
138 and 420.
lord, surprisingly, the same thing, the 1cc
By the
case
way,
has
why
been
don't you pay
stayed.
the money?
Milords,
You are
there is no,
suffering 138.
Milords,
you are
there is
suffering
no
there.
question of payment, Milords. There is no question of payment. But if your lordship will see from annexure 2, what she has stated in her complaint itself is that the accused was a
420 is a distinct offense.
Yes.
And 138 is also a distinct offense in a different statute. Both the things can go together.
Milords, when the learned magistrate himself, after going through the entire complaint at a glance, could not find a case of cheating or misappropriation, Milords, he had issued a cognizance under 138 of the NI Act
No,
because of the fact
show
that.
the complaint, whether there is a
Milords,
composite
I have-
complaint. Was it a composite complaint?
Yes, Milords, I have
Very so
annexed it at annexure 2, Milords. Milords, you may see at page 14.
Where is the composite to?
Page 6, point number 6, Milords. She
Yes.
has categorically stated offense
Yes,
committed is.
highly should. Because along with 138,
And
420
admittedly,
was-
those transactions had taken place in the year 2016.
issue notice. Bring him. But still you have to pay the money. In 138, in any case, you have to pay.
Well, that is subject to what now the case has already started and she has also examined herself.
I am only
At the
issue notice
behest of the
because in
informant.
138, what he should have done is, in 138, he has incorporated 420 also.
At the behest of the informant now, she has come up and stayed the matter in 1cc case. After the she has filed FIR.
27.
My lords, I may be permitted to submit on behalf of Mr. T.R. Singh, my lords. My lords, here is a case and counter case. The petitioner number 2 in this case is an practicing advocate of Brothel Bar Association and the wife or husband of the informant is a journalist. My lord, the brief fact of the case is they both used to stay at one place and there were 2 rooms. One was occupied by the journalist, one was occupied by the advocate. While the journalist was not in home, he had parked his car in front of his adjuster's home. That is where the dispute started. My lords, if your lordship will see page 23 of the charge sheet. At page 23.
Yes.
My lords, after 20 lines from the top, it starts with during course of investigation. My lords.
Yes.
It is ascertained that Pradipta Kumar Dhola and opposite party member Ajay Kumar Giri bought one house from Binay Mahanti. There are 2 rooms. Pradipta Kumar Dhola took 1 room and Ajay Kumar Giri took 1 room. But as the family member of Ajay Kumar Giri reside at PhD area Brothel, he often visits the said room. Due to this, Pradipta Dhola kept his vehicle in front of his room. Due to this, dispute arisen.
Parking dispute, basically.
My lords, it's a and
What
it
is the-
culminated.
what is the cross case?
So exactly same, my lords. In this case,
Where is that the case?
My lord, that is annexure.
Have you filed any petition?
My lords, annexure 4, man. Annexure 4.
Annexure 4.
Page 27, man.
Any petition is filed?
My the FIR is filed. In that, my lord's charge sheet is not filed. In my case, they have filed charge sheet and the magistrate has taken cognizance.
Your complaint is not ended up with charge.
No, not ended with charge sheet here. In
I'll
this,
issue notice, bring them, we'll settle
My
it.
if your lordship.
Both the cases have to go.
My lords, both the cases.
Parking issue 1 and 3.
My lords, if I will request your lordship, if your lordship will grant some kind of interim indulgence, then it will be settled, my lords. If your lordship will only issue notice, it will not settle. Some kind of interim indulgence, my lords, it will settle.
See, 41 notice was cancelled.
My lords.
Nothing happened. Now charge sheet is filed.
My lords.
You move application. Move application for the counter case has been filed by the client against the party. investigation of which has going. And the further submit that the input is arising out of a minor misunderstanding regarding the parking of the vehicle. There is a large scope of out of course regarding that the judgment made by the issue notice to opposite party. In the meantime, petitioner can move an application before the trial court seeking an adjournment. If such application is and shall be considered.
Great.
28. May I please? Conviction for period of 2 years and pay fine 10,000.
Appeal.
Yes.
Regular appeal, 2 years.
Realization of file state, bail granted, yes.
Okay.
29.
3 years.
Same order, 3 years. Yes.
30.
30 of
4 years.
same order. Huh?
In custody.
Granted, 30
May I pray to direct the registry to indicate vigilance in the cause list? Last one, 30.
30 state of Orissa.
Vigilance in the
30 days granted.
Oblige.
31.
May I please, your lordship? My lord, I am in BC, your lordship. My lord, it's a bail term matter. My lord, the release on bail on 27/9/2023 and NBW issue on 18/12/2024, your lordship.
Yes, allowed.
32.
It's bail jump matter. He was released on, the 3 petitioners were released on bail on 13/7/2023. The NBWs have been issued on 25/3/2025.
33.
It's a Belgium matter. NBW issued on 20th September 2024 and they are released on bail 13th January 2022.
34.
34 minutes.
Yes.
Your Lordship may kindly see the noting minute. The notice so far as the OP number 5 is concerned, neither edit back nor anything back. So my Lordship may presume that it has been deemed solved because nothing has returned.
In the review petition which you have
Yes,
filed,
Minutes. In the review petition, that review has been accepted.
where is the impugn order?
Minutes, about in the that minutes, read petition minutes, answer 6. Answer 6 in the review petition.
Review why you not file?
Minutes, in the review, minutes, minutes, my prayer has been accepted. Lordship may kindly have a glance to the order. Lordship may kindly have a glance to the order. That is order dated 15/4/2011 minutes.
15/4
2011. Lordship got it. Considering the nature of prayer made in the WPC number so and so and order passed in on so and so, the review application is accepted. Then notice issued in the even though in the review, but deemed to be in the read petition because it is accepted. Review has been accepted.
But I'm surprised, but the petition is filed, even impugn order is not attached.
Yes, that should be that should be madam.
Why it is entertained, I don't know.
Yes.
But I can't do it because
but the impugn order is
11 it is pending.
Madam, the impugn order is the quoted minutes. That's me kindly seen.
Should file in?
Yes, yes.
What is it?
Yes, should be. Yes, yes. That should be. So it isn't
Not
active.
a single annexure.
No,
Not even impugn order.
Impugn order is quoted in this order.
Now, what to do?
Madam, your Lordship here the student for the so far the listing is concerned. Yes, madam.
In case of the notice of opposite party now filed by the issued post, areas are to be taken in few days, failing with parties stand. Parties failing with the petition shall stand dismissed without reference to the court. Have you taken the step?
Yes, madam. That day it wasn't taken. Now it is madam.
Just see, pursuant to the order dated 7/4/2019. Whether a step is taken?
7/4/2019.
Last hearing.
Order. But the noting is this. I have not. then, my lord, see, with the 19 order is not, but the noting is that neither the,
You have sent it
yes,
to 5 and 8, huh?
my lord.
By registered board.
Yes, my lord.
With AD fixing 6/5/2019 for appearance.
Yes.
Yes.
Now there is,
Neither the answered notice nor the postal lady has been returned from opposite part with service is not complete.
since not nothing returned, so it is,
Service comes.
okay, my lord. So also my candidate took take steps.
Yes, you have to take first.
My lord.
The petitioner, the service on opposite part not filed is not sufficient. The petitioner to take first steps within a week by filing the refugees. This is the matter of.
Your lordship, after vacation, any date?
Yes.
Okay.
But you take it, why after vacation? We'll finish it.
All I don't know. I'm ready. Within a week, this week I'll text.
If you can, sir.
Yes, yes, yes. I'll text. Okay. Okay.
35.
May I please, your lordship?
Yes.
I'll just clarify regarding the miscases that has been placed on your lordship's board. IA, your lordship will see 46
Opposite part note or report indicates that.
That's a petition for substitution. My lord, got it, my lord.
1 to 5 application.
Substitution. They have to be substituted to 1A to 1D.
Application? Which application?
IA 46 of 2024 at flag C.
Flag C. Yes. This is.
Man,
This
there are certain notice has to go to the IA.
No, this IA has to be allowed. 47 and 46 and 47. Isn't it?
47 is with regard to substitution of 5. Somebody on record as OP 9 and 10, so his name is to be.
What is 48?
48
3
is deletion of name of petition number 3 because others are on record. Other
then,
heirs are already on record.
Okay, then 46, 47, 48 to be allowed.
Madam 46, if you like, 46, I think the notice is to go to the heirs. After the committee, you'll actually consider allowing. Because substitution of OP 1 is not for the heirs may have a say in the matter. I do not know, my lord. So far as the substitution petition is,
I will allow the substitution petition and issue notice to the LR. Right. Allow the application 6, 47, 48. Huh?
47, 48 is to be allowed, no notice is necessary. 46, after allowing, a notice should be sent to those persons.
LR, 46, 47, 48. The 40 deletion. You want deletion, huh?
47, it will be substitution, but heirs already on record, so therefore he has to be deleted.
47 means 48.
48 also same case.
Okay. That's okay.
Then
Yes.
notice on 12 may be treated as sufficient. 12 because I think my lord, the tracking report has come.
Okay, I'll do it. Nice.
And one more prayer, your lordship. I'll file the requisites by day after tomorrow with regard to the substituted heirs of OP1. Next day.
Yes, next.
36.
Appearing for OP number 2, it may be recorded.
Yes.
Lord, this.
Yes.
This there are 4 cases, 3 cases of mine. But what happened, this GI case we have succeeded. For this honorable court by my lord, the Chief Justice, in one day, 300 cases were disposed of without giving a notice. Mainly similar order has been passed. It order has been recalled, FAO restored to the court has also given an opportunity that you have to file a review or recall. I have filed this review for that. Similar matter.
Where is the impugn order? First
Yes,
one.
Annexure 1.
First one.
First one was Sabuda Beach. Court, it is page 10, page 10. First one. Same, similar, identical order, my lord. My lord need not to see all this. So, para 6 region. Liberty was granted to file within a month. That is filed within time.
Very similar.
See, this impugn order is different than the impugn order in those matters.
Pardon?
Impugn order in those matters are different than the impugn order in this matter.
No, same madam.
Not
Same.
Not
1510, 1510, 1610, 340
not
cases.
same. Just see, in this case, it was disposed of relying upon Anup Senapati.
Every case. But that
Where
was
is
Loknath
that order?
Behra.
Show me impugn order in those cases. Those cases, impugn order is, reproduce. No reference to Anup Senapati.
No, they have reproduced only the para 6. My lord have reproduced only para 6, where the liberty is granted. Same part. Other part has not been reproduced.
Can you please give me the impugn order of this? So that
Yes,
I
yes,
can
my lord, I
pass
am the
it.
counsel. Like just now, I don't have.
I'll put
My
it
lord,
after a week or so. Get those orders.
Tomorrow, my lord, it can be disposed of because there is no
I can-
quarrel over that. I will only just show
Let
to
it be 20 seconds, huh? 20 seconds.
ବର୍ତ୍ତମାନ କଣ ହେଲା
Tomorrow.
ଏବେ ଗୋଟେ ବେଚ୍ ଅଫ୍ କେସେସ୍ ରେ ଡିସ୍ପୋଜ ଅଫ୍ ହେଇଯାଉଛି ବର୍ତ୍ତମାନ ଆଉ ଗୋଟେ କେସ୍ ଉପରେ ହେଇକିରି ଗୋଟେ ରିମାଣ୍ଡ ହେଲା ପରେ ଡିସ୍ପୋଜ ଅଫ୍ ହେଇଯାଏ ଲୋକଟା
I'll
ରହି
tell you what happened.
only
I'll tell you.
yes madam
You know, I was the lawyer in Anup Kumar Senapati.
yes
How many applications were filed in Supreme Court? Do you know?
thousands madam.
More than 6,000.
Yes,
All are misleading.
nahi,
I was dealing with that. I had to work overnight to sort it out.
correct, but that is not
You
the issue
don't
here.
put this so simple.
That is not.
I know.
Yes,
I know
this-
what happens.
This is the simple thing.
I
is,
want to see their impugn order.
yes, all the simple notice is one date a
No,
same
no,
order.
there is no reference to Anup Senapati in that.
yes ଗୋଟେ ଦିନରେ ଆଜ୍ଞା 340 କେସ୍ ଡିସ୍ପୋଜ ହେଲା 15 10
Moreover, I'll tell you.
I will give it. There
No,
is
you
no
are
quarrel
covered
over.
by Anup Senapati.
Which one madam?
If Anup Senapati covers everything, why should they review?
No, review is only for that. I have not given him an opportunity. That is why the court has granted the liberty.
I will hear
Court-
if you are covered by Anup Senapati is
Court,
covered.
court has granted the liberty. Court has granted the liberty to recall. Unless that recall, my lord.
Why to keep it pending?
No, I don't want. It has to be recall and FAO is to be heard. Not this review.
FAO goes because of Anup Senapati.
But here in this case,
As
my lord,
simple as that.
that is here the case is
That's what
tribunal allowed my case. By referring to Anup Senapati, this honorable court allow the government's FAO without giving me opportunity of hearing. That is the point, madam. That is why I filed the review. When court has also granted.
Formally it has to,
Yes, that
formally it has to be restored
no,
again.
because now, my lord, now a coordinate bench judgment. Today also I at item 83 and now I am going for another case 102. All the cases at different judgment has come by this honorable court, a coordinate bench, my lord. There the honorable court has said
to which part Anup Senapati has not taken care of, the tribunal has taken care of, necessarily this Honorable Court has taken care of, and remanded the matter to the government for reconsideration. So that is the point. They will also get the same relief. Otherwise, they cannot get more. This is the development.
All these things has to go to the government, and government should decide.
Government will decide. Yes. जो part छाड़ी जाइए sir. सही part.
I will record that and dispose that preview.
I can give you that judgment also.
You give that, I'll
ମୁଁ
dispose
ଦିଟା
that.
ଦେଇଦେବି ଏବେକାର ଯୋଉ ଜଜମେଣ୍ଟ ଟା ହେଲା honorable judge ଙ୍କର ସେଟା ବି ଦେବି ଏଟା ବି ଦେଇଦେବି ଯେ ଚାହୁଁଛନ୍ତି ଦେଖିବେ
So that I can dispose of the review petition, the entire petition. Again, restore the FAO and the same order has to be passed.
FAO ଟା ଆଜ୍ଞା assignment ର
Why
ଅଲଗା
to this court?
ନାଇଁ difficult technical difficulty. I have no problem. I will get a order
I'll
from this
exercise.
court.
I'll
ନାଇଁ,
exercise.
FAO ଟା sir ଆପଣ review ଟା ଆପଣଙ୍କର assignment. FAO ଟା ହଉଛି ଅଲଗା assignment.
That's right. But
That is the problem.
While exercising review, I can pass that order.
My lord can pass, but I am here to assist my lord. Because this is
You get that.
yes, both the order I can use. Or end of the day, my lord, it will be remanded to the government.
22nd.
22nd. Can it not this week?
No, these 3 days is very, very tough.
छोटो केस उड़ा सॉरी and if people लोग को उड़ा इतना उड़ा केस ହେଇଗଲାଣି ଯେ ଆମକୁ ଟିକେ
22nd.
आगे
Get that all the orders so that we can, take a view.
Actually fact I cannot mislead this honorable court my lord.
I'm not saying you are misleading.
15-10
I'm worried that unnecessary cases are pending.
Yes.
We can send it to the government. Government can
government
take
today
very light of
old court number 1 there are about more than 50 टा केस ଅଛି ଅନ୍ୟମାନଙ୍କର ଅଛି ଗୋଟେ ବେଚ୍ ଅଫ କେସେସ୍ ଦିଟା ଆଇଟମ
go to government.
yes now just ମୁଁ ଦିଟା ସାରି କେସ୍ 80 to 83 ରେ so government
Get those orders also. We will
503 ରେ ଗୋଟେ ଏବେ ଜଜମେଣ୍ଟ ଯୋଉଟା ହେଇଛି FO 509 of 14 ରେ ସେଇଟା ଡିସ୍ପୋଜ ହେଇଯାଇଛି
Yes.
but ଏଟା ରେଷ୍ଟୋର ନହେଲେ ହବନି that is the point.
My lordship, let them serve us a copy. We don't have a copy, my lordship. of that.
Copy. Give it.
Oh, I will.
Yes. 38. Okay, 37.
Right, Your Lordship. On the last occasion, Your Lordship directed to issue notice.
Can I come within 2 minutes?
Oh, yes.
In the reverse manner. Wait till 2 o'clock.
My lord.
We'll do it. Don't worry. Even if you are not there, send the junior. I'll do it. I know now. You may not come. You send your junior.
Okay. Pardon, my lord. Item 80, my lord. Compromise method. Victim present, my lord. So, I see a small child.
80.
80.
I'll just take it up. There is small child. 80. 80.
The delay, my lord, it is an inadvertent delay, my lord. What has happened, my lord? During that period, I'm placing the fact, my lord. We are abstaining from the court work, my lord. And this matter was listed and it was passed that if defects are not removed, then it will be dismissed automatically. Thereafter, subsequently, I could not know about the case, my lord. Then a batch of case was disposed of by this honorable court in the year 2023. Therefore, my lord,
You oppose it?
Yes, my lordship.
Yes.
Because my lordship kindly have a glass 2,374 days of delay.
1,000.
Yes.
My lord,
And
there is
the
a
order-
5 years.
It's all right, but strike was going on for how many?
My lord, there was strike was going on for around 3-4 months, my lord.
Yes.
So I could not
I
know
give that
about.
concession. Okay.
No, my lord, I could not know about
5
that
months.
case. When
Concession given. Thereafter-
when this honorable court, similar batch of cases were disposed of by the Honorable Chief Justice and Justice Raman in 2023, I found out I will file these cases and it will be similar order will be passed. 5 cases.
First time, resort to strike is not permissible. Second, you are not diligent thereafter.
My lord, thereafter I could not
What they are saying, my lordship.
find it out. But my lord, what has happened? Same plot, same khata number of different my lord person. The 5 cases were allowed by this honorable court.
Show me that.
Only, my lord, I'll file this. For that reason, on the last occasion, direction was given to obtain instruction. My lord,
No, no.
5 cases were disposed of
Although
on the same khata and same plot.
notice was issued to opposite party number 2, however, Mr.
My lordship,
Sarvamana, who appears for opposite party number 1, submit that he will be appearing for opposite party number 2 as well. And she, I agree with you. There is a delay of 2000.
2,374 days.
2,374 days delay. She wants to file response to the application. Please, madam.
May I please, your lordship? But I think they are giving a wrong submission because last occasion, kindly have a glance to the order dated 17/1/2025. Issue notice to opposite party number 1, not to opposite party number 2. Because here written.
Anyway, party number 1 and 2.
Please
both
verify
Only
the
the settlement.
last date.
Like,
Last date it was written.
He
My
can
lord,
be-
my lord, yes, my lord. Notice can be waived. My lord, I will
Notice
also
waived.
supply the order copy
Yes.
of the
Yes,
connected matters, my lord. 5 cases were allowed.
You
only
get
this-
that.
My,
We'll see. Yes.
my lord, fixing it to
Yes, after a week or so. Yes.
oblige, my lord.
May I please, your lordship, I am on BC, my lord. It is a modification of order. The case has been disposed of on 5/3/25. In paragraph 2, my lord, kindly see, it will be Commissioner for Joint Labor Commissioner, Jaspur. But instead of Jaspur, it has been reflected Cuttack.
Order दिखाइए जाजपुर को order dated 503 first second paragraph पे कटक लिखाइए commissioner come employees
It will be Jaspur, my lord.
joint commissioner कटक लिखाइए जाजपुर ठीक है
And my lord, on that paragraph, on last line, my lord, kindly see, the truck bearing number should be OR09. That will be inadvertently OR19. That 19 will be corrected to 09.
1909 ठीक है there are two problems para two इधर जाजपुर हो और 19 number 09 okay
Obliged, my lord.
yes 40
But I please, your lordship. Last occasion, your lordship.
Directed to serve the notice through IIC, but yesterday I just called them, but they are all busy in the yesterday program.
Busy
In the that Ramnavami and all those.
notice was directed to served on opposite party number 2 through the IIC Kujonga police station.
Yes.
However, instruction from the police station has not yet been communicated to the state council, and she seeks an adjournment, leave the matter afterwards.
Lordship, may I request your lordship? A short date, may I?
Yes.
41.
Notice already deposited, madam.
Sorry?
Uncle, requisites already deposited.
498
Filing.
No.
अच्छा requisite filed for serving opposite parties to utilize for the purpose of service. Yes. 42.
Thing is that notice has been answered. My lord, I will file within a week, not corrected address.
Steps to be taken to serve opposite party number 1 to 3. 1 to 3. Yes. 43.
May some rejection of a 311 petition in a 138 NI Act that.
Yes.
And the scheduled questionnaire is the middle. That is middle. Running page 23 annexed 3 middle. And middle the handler as per the complaint middle handler taken by the husband of the complainant. And since he being the legal married wife, I, as per her case, I should check her. You should check in her neighbor, and subsequently that has been got dissolved. And this case, question on page 23.
Where is deposition? Why have you not put those questions? Very extensively cross-examined her. Just see from question number 12 to question number 36.
The relevancy of this question 23.
And this was done when statement was recorded on March, 3rd March 2023. And you move application when? 2024, after 1 year. And what are the questions? Let us see what are the
That is. How
installment
many
is
installment your husband paid to the total amount to the accrual? Whereas because my lord, as for husband given money to me, that's why the my lord conflict.
Why have you not put these questions? What are the explanations? No explanation. What kind of question number 5, Jesse? The ink used in the name, amount, date, and check.
When you are my lord,
Different. This is the question you want.
Question number 2, my lord. When you are
I don't think I can allow it, but let us see. The issue notice to the party.
issue notice
But I just left.
Who is appearing? Service. But yes, all right, but you have to serve opposite party.
Press notice to be issued.
Press notice to opposite party. Liberty is granted to the petitioner to serve opposite party through the counsel appearing for him before the trial court.
1 minute adjournment. Sorry,
What is the stage?
Sorry, me case,
What is the stage you tell me?
Complaint and sorry, evidence may further.
Oh, you serve first.
Adjournment
1 week, 1 week. No, 138 I can't do that. Yes.
130 notice
See 2021 complaint. Within
Yes.
6 months it should have been over.
Yes.
We are in 2025.
Yes.
After 1 year you move application 311.
Yes.
You have all substantially you have cross-examined.
Because
And there is no explanation coming forth. So therefore I will not do it.
Because whatever question, my lord,
All these questions are irrelevant.
Irrelevant.
For the purpose of 130.
husband delay could you have.
For the purpose of 138, all are irrelevant questions.
So delay happening. Suppose next date
Anyway, first of all, I will see, I will allow or not. I am just exploring a possibility of settlement. That's all. 311 is not. See the questions.
Yes, questions relate to her husband because
Is it relevant for the purpose of 138?
Establish career particular Miller James say
Question number 12 to question number 36.
Yes.
How many questions you asked? As against how many questions in examination in chief? Just see.
More questions from.
Just see how many questions in examination in chief, and how many questions in the cross examination. And after doing that, after 1 year, you move application. Don't waste time. I may pass an order against you now. Sir. Yes. Through council. Through council. Yes. 44. 44. Yes. Notice sufficient. Let us see, pass it over. Anybody, somebody may come. Notice is sufficient. Okay. Pass over.
Let it come next week anyway. Let it come next week. Interest already been compromised.
So therefore, I am just passing it over because the notice is sufficient. Somebody may come appear. Yes.
45. Your lordship, can you see the noting?
Noting. What is the noting? Sufficient. Okay.
Sufficient.
Sufficient.
Let it come next week.
Okay. Notice on the response. Please, opposite party number 2 or what?
Opposite party number 2.
Notice in opposite party number 2 is sufficient. However, entered here on behalf, please the matter. On her behalf, please the matter. After 1 year. Yes.
Date please.
Yes.
46.
6.
I think the lordship, I'm filing an application for correction. Consolidated cost rate filing. Not to the extent it has been erroneous. I'm repeating the name of the petitioner instead of the mentioning the father of the opposite party number 2. the cost title.
No, what about the notice?
Notice to requisite be filed by then that may be extended. Only notice your lordship is given. by requisite.
Pursuant to the order dated 9/4/2025, requisites have not been filed. 1 week time is sought for filing the requisite, let the petitioner file the requisite to serve for the particular. And then what do you want? Mr. Das? No, what, there is a correction.
Opposite
Want
to-
a correction? No, you want correction of something. Wrong. Cost title correction you want?
Consolidated cost title. In place of
Opposite party number
OP
3.
number 3, name of the OP number, other of the OP number 2 should have been mentioned.
Whatever. Mr. Das, let us for the petitioner submit that there is a typographical error occurred in the cost cycle for the petition. He seeks to amend the cost cycle. Amend the cost cycle. He will do so and find the concentrated review of part. Huh? Have you moved IA?
For amendment of the cost title, my lord.
Amendment allowed.
Application should be filed.
No, IA for amendment. Yes.
Only for IA for amendment.
Yes, next.
47, my lord, 3 matters.
So for first matter is concerned, second, third, or are interlinked with each other. Second, third item, sub-item, my lord, today I filed my Baklatnam on consent. So for third item is concerned, government has filed the counter. Noting was that counter has not
Counter
been
is
filed
filed by OP 5.
by OP number 5.
And apart from that, my lord, lordships, there is a IA, further orders in first case, your lordship.
So for first case is concerned, that is
There is a
interim protection.
further orders, I would have revival of read petition.
No, you will appear for petitioner now.
Yes, for second item, sub-item, my lord, I am for the OP, contesting OP. The third item, I am for the petition.
What about the first item?
First item, I am for the petition.
Mistake further order regarding revival of read petition. Revival of read petition.
Let us see what is the
Yes, madam.
main petitioner does.
So let's get on to the second item, second and third, because second and third is important for the first.
Yeah.
So for second item is concerned, my learned senior friend, Mr. Brothel is appearing.
Yes. What are you seeking here?
Here, I have also prepared a notes of argument.
Yes.
Can I supply me?
Yes. Then
The bid.
next is what?
Counter উপরে দেবো। The lordship is
Got it.
দেখিলে very well.
You got it? Got it.
I am just, I'll, because the state is a formal party, so for second item is a comment as file a counter. It's a dispute between the.
Not a formal body, by order is also telling position.
Are-
Yes.
My lord.
Yes.
One just order of the learned LRC, my lord, is challenged by both the parties.
Who all are appearing for contesting respondents?
My learned friend is appearing in this.
You are ready?
Last item.
Ready for
The
you?
last item.
Got a copy?
Yes, sir, just now, sir, my ignorance is friends of.
Are you ready or you will prepare?
Yes, I am ready.
Yes.
Yes. Solve the capital, my lord. And look, I'm counter. No, rock. Government is a formal party, my lord. It is a
I'm
dispute.
just asking whether you people are ready, then
I am ready.
start. Otherwise,
I am ready, my lord.
Just give a date.
That is very simple, but it is 4 to 3 to 4 repetition filed and challenging the same order.
Then second read petition I am hearing.
Yes,
Second read
second
petition
and third is
decided-
interlinked with each other.
Yes, second read petition is
That
decided.
one is also linked with all these things.
All the read petitions are linked, but which is the main petition? Second one.
Second.
Second one, let us hear one.
Yes.
Yes. How much time will you take?
Lord, I will fire. Only provide 3 judgments and
How much time will you take?
10 minutes. Ma'am.
10 minutes. You? 15
Let my friends start.
3:30. Keep it 3:30. Come at 3:30 and dispose it.
Second half, my lord, I am.
Because other people are waiting.
Your lordship, may adjourn to any other date, or that it will be covered.
3:30 you come, I'll dispose it up. Three read petition, there is
I
nothing.
have other work, my lord. That's why I pray after
Okay,
lunch.
personal difference.
Yes.
It comes from other.
Yes.
I will file it on box, on the registry.
You file and supply the copies.
I already, sorry.
We'll sit up. One. Yes, I'll give a date. I'll give a date.
So far, first item is concerned, my lord, that is an interim protection. Let it be.
That will continue.
18% may be vacant, my lord.
Maybe vacant.
Because the suit of 98 and these.
That's the reason I'm saying if you want to argue it, come at 3:30. I'll dispose it up. I have seen that 3:30, 1988 suit.
Yes.
It's unnecessary pending.
Unnecessarily dragging on the matter by filing.
It will be dragged. Short date has been granted. No.
Keep it on third, huh? Third Saturday.
Third.
May, Saturday. That day you come and I'll dispose it up. That's best way.
I will file this.
Yes.
That
You exchange. Yes.
May I pray, my lord, that first item, that interim protection be
Interim
completed.
order.
First item copy ଆପଣଙ୍କ ପାଖରେ ଦରକାର ନାହିଁ ନା ଫାଷ୍ଟ ଆଇଟମରେ ସରକାର ପକ୍ଷ ନାହାନ୍ତି
Yes.
ଫାଷ୍ଟ ଆଇଟମରେ ସରକାର
48. Yes. 48. Yes.
But in this case, we had filed a notes earlier, your lordships.
You have filed the notes?
Yes, sir.
Written notes.
Along written notes along with in 2020, because this matter has been heard by at least 3 benches, but anyways, for some reason or the other could not be completed. So the written notes have been filed since 2021.
Yes.
And in fact, after that, we have added couple of judgments, which I'll give it because the earlier note of citation that doesn't contain it.
What is the issue? Passing? Seeking passing of what?
Passing of proceedings under the Drugs and Cosmetics Act. Where your lordship would see.
Drugs and Cosmetics Act, perhaps at that time was, and also PC Act, under the PC Act, prevention, PC Act, I'm sorry.
NDPS.
No, it is not essential commodities.
Essential commodities.
PC Act. The written note is the पुराना फाइल है ऐसे छिंको है लगा the copy is.
Yes.
So if your lordship can take up the written notes.
Yeah. Yes. Who is appearing for the other parties?
No, the state is better. State is. My learning friend is a little handicapped because of the written notes. I think the copy is not.
You got a
Let him, my lord, copy we saw, and mine, on that day I'll give the reply or your lordship.
Are you ready? Then I'll proceed. Otherwise, unnecessary. After 10-15 minutes, you ask for adjournment, then it's not. Other people are-
Written note, nahi, file.
In course of the day, I'll give him.
The written note of submission has already been filed. However, the copy of the same is not available with the state council. Therefore, Mr. Nanda undertakes to supply additional copy to him. Leaves the matter when? You tell me, these matters are pending for years, there is nothing.
Any day, your lordship's going to.
Huh? 30. We'll dispose it up.
Absolutely.
Interim order.
49.
49. But affidavit has been filed and stayed.
Yes.
You have to give a copy to me. You have to give a copy to me and also the correct 29, 30.
30th. 30th. The state, the opposite party in the state has filed an affidavit pursuant to the order dated pursuant to the affidavit. Have you filed affidavit?
Affidavit is noting, my lord, the affidavit is the state.
Affidavit flag B.
Flag B.
You filed the affidavit. Flag B. Do you have the copy?
My lord. I will take this copy, Xerox and return.
Okay.
Well, I am for the OP2, my lord, complainant bank. My lord.
The copy of the same is to be supplied to the petitioner. Leave the matter for disposal on 30th. 30th. Interim order to continue. Yes.
50.
But I am for the complainant bank, my lord, the appearance.
Yes.
Is the same case where under the Violence Act. The petitioner is known after the order. After was the help of the affair of the company. And no sanction has been obtained with regard to the petitioner. You are going to suspect I can see the last changes. You will not the confidence order, which is a very cryptic one at page 83.
Yes.
Article 3 state versus Mohan Singh, the older
83.
83 man.
Yes.
That's a fact. It is 2CC case number 78 of 2010.
Yes.
Mohan Singh, who incidentally was an integral Hindustan Coca-Cola Beverages Private Limited. By the time the alleged occurrence happens on, he was on employment, he got a first day of that. And as you can see, the Cognizance order. Here under section 24C of the Indian Boiler Act and 23C, that is accused Mohan Singh. There is the here, and case under section 24C of the Indian Boiler Act.
Indian Boiler Act.
Accordingly, Cognizance is taken, that it suffers to the accused.
Yes.
Find the
Yes.
And Article 9 will be. Reproduction. 26. On the Boiler Act.
Yes. Yes.
No prosecution of an offense made punishable by or under this act shall be executed except within 24 months from the date of the commission of the offense. And no such prosecution shall be executed without the severe action of the chief inspector. Dr. kindly come to page 73.
73.
73.
Okay. In 73.
As this is the sanction order. And what you could see, admittedly, the sanction order has been issued on behalf of the director. For the director of factories. It is not as is required in the section 26. And as pointed out in your investigation report, sanction of the prosecution is accorded for violation of section 12 of the Indian Boiler Act 1923. Here we find against the owner of the aforesaid boiler.
In connection with the aforesaid incident.
Yes.
The copy of
So first of all, it is not given a sanctioning authority. Number 2.
Secondly, sanction is granted for violation of section 12,
Section 12.
where 24 violation is found, and owner.
And also kindly see the permission. Another form. D at page 57.
57. Yes. Yes. Founding.
The director of factories.
Report of SK Vera. Director, petition, boiler. Yes.
This is the genesis of the complaint to file. In accordance with the above referred letter, I have held final inquiry into the incident and the circumstances attending it with the boiler number OR 645. Horizontal multi-tabular straight
Yes.
side.
Following report. Date of incident 25.
And consequently, number 3. Name and address of the owner. Village Ramchandra Tingle.
Who are you then?
I was an employee of the company, but that won't say. And section 2, so 12, can you see what is section 12?
Yes.
Section 12 is alteration and renewal to the boilers. No structural alteration, addition or renewal can be made. These are to any boiler registered from this act unless such alteration, addition or renewal.
Yes, Mr. Vishwal.
Yes, ma'am.
You are prosecuting in 24 or 12?
The violation of.
Sanction is given in 12.
Yes, my lord.
Prosecution is 24.
24 is
It was given, the sanction is given for the owner. Owner is someone else.
No, my lord. No, my lord.
Yes, yes.
Yes, your lord.
Yes, please.
Section 24 says, 24C, A and B have been deleted. Any person who, section 24 the other period.
Yes. Violation is 12, penalty is 24.
Yes.
That's what.
Yes.
Yes. You've seen that.
So, but where is the alteration? So there has to be a private finding inquiry. Then the alteration happened during the time when I was the help of parents. First of all, I am not a owner. And the sanction is for the owner. And the owner has been shown that 57 feet within Ramchandra finger. And admittedly, the section 12 alteration has been done much prior to my joining in 2010 October. And I joined in October 2009. And all the alterations.
Show me the allegations. Whether the alteration is done
Yes.
on the supervision.
Yes,
Supervision.
there is nothing on the contrary.
Whether if it is done under the supervision, under the provisional sanction is not required. Let us see.
3 at page 34.
34.
4.
Yeah.
It is 6th of February 2009.
Yes.
With reference to the above, the drawing so and so showing the proposed modification by addition of that of imbue use for enhancing the capacity from 3 TPH. So TPH is not
Up to 4 TPS. Okay. Is approved.
is approved.
And
And
a
a
copy
copy of
of
the same is sent here with the receipt of which needs to be acknowledged by the director of factories. It is much prior to my time. Then what you will see. Next page 36, correct?
now the boiler shall be offered for the inspection in the prescribed manner to the Assistant Director of Factories and Boilers, Bhubaneswar Zone 2, for necessary action at his end. So then, under the supervision of the competent authority,
Oh, yes.
the alteration has taken place.
And have taken place and also alteration is taken prior to my time.
And then in that case, sanction is not required.
Not required. No,
So the sanction is irrelevant now.
now sanction.
You are showing me the sanction letter.
They are saying.
You are trying to point out the sanction is defective. Sanction is not.
What I'm saying, they are saying that section 12 has been violated. And since section 12 has been violated, sanction is required.
Not required.
So there is no violation of section 12.
Now just see 12. Come proviso to 12.
Yes,
Proviso 12.
provided that no such sanction is required when the structural alteration additional renewal is made under the supervision of the competent person.
This is the letter which you are showing.
Yes.
It shows that there is a supervision.
So it has been done.
So sanction is not required. The sanction is now irrelevant.
So that means that the entire thing has gone on the wrong basis. As if whether the alteration has been done unnecessarily And since the alteration has been done on a condition, sanction required, sanction granted to the owner.
Sanction is not consequential at all.
So now thing is that whether the prosecution could be sustained against it when you got the order.
How will I?
And that is no material to show well. I showed you ultimate page 57. In the inquiry in the form number D, it says the owner is within terms of the finger. Inquiry conducted by the parties only.
Where is your appointment letter?
At page 57. sir.
Appointment letter. Your appointment letter.
But I have mentioned in the paragraph 4 of my application. I have made.
Yes, Mr. Vishwa.
And one more thing of my say that page 57. That inquiry. And whether the coverage, I mean the complaint petition, it's a replica. And though here it is village and if the complaint mine and comes out. How do I?
Let us see what is he saying. Yes.
In
Who is the owner?
owner is the, your lordship, before I going to the merit of the case, I will bring to your lordship notice the definition of owner. The definitions of the owner is 2D.
Yes.
Owner includes any person using a boiler as agent of the owner thereof, and any person using a boiler which he has hired or obtained on a loan from the owner thereof. Owner includes any person using a boiler as agent. Admittedly, the petitioner is the factory manager by the definition of the owner. To be
including any person possessing or adding.
lordship. Yes.
Including any person.
Includes any person possessing or using a boiler as agent of the owner thereof, any person using a boiler which he has hired, obtained on the loan from the owner thereof.
Even the person who is in possession also to be treated as
is treated as the owner. How?
Now owner definition is very wider. Let us see the complaint.
Yes.
What is
your
the
lordship, your lordship,
come to the complaint.
Yes.
Your lordship, that petitioner
Yes.
is the I am saying that he is the owner. Your lordship, we are relying on the a power of attorney executed in favor of that petitioner.
Where is that?
Page 79, well. Page 79.
You are
Total to whom the present shall come. We the Hindu so and so company incorporated company act and having the registered office so and so Gurgaon send greetings. Whereas SCCB has a manufacturing plant plot number so and so. Whereas the board of directors of SCCB in board meeting held on 40th November 2008 has authorized any one of the directors of the country jointly with the vice president, legal company secretary to grant power of attorney on behalf of the board to associates to the company for routine matter on need basis only to perform any or of the acts, deeds, things specified hereunder in respect of the said plan. And whereas so many names and the petitioner's name found place at B.
Yes.
Mohan Singh, factory manager, to perform all or any of the acts specified under clause 10, 11, 15 and 17D. Your lordship kindly turn to clause 10, 11, 15.
10.
Page 81.
10.
To sign, execute, file returns, form such other documents and to do such other acts as may be required to ensure compliance under the various acts, rules, regulations applicable to the said plant,
Provided.
including the Atomic Energy Act, Petroleum Act, so and so, and the Boiler Act.
Yes.
The Apprentices Act 1961, so and so,
Yes.
Bureau India.
Yes, I
Fruits.
got it. I read it.
Then 11, to sign, execute, file application and other documents required for registration,
Yes.
transfer, surrender, telephones, so on so. Then 15, to sign, execute, deliver application agreement, the state electricity
Yes.
in respect of electricity connection, purchase of power for operation of the said plant. Then 17, to enter into, execute, terminate, sign, seal, deliver of the agreement, security services, contract labor, canteen, travel agent, retainers, consultants, then transport, hiring, so on so. This is the power of attorney executed in favor of the petitioner. So, in view of that decision of the owner, the petitioner is the owner of that.
Anything else?
Then so far as the
Yes, sir. Are you like, intend to add anything?
That power of termination is given. Doesn't say that I am authorized to do something with regard to.
The owner definition is very wide.
No, owner definition of the NDC.
Yes.
The owner says, let me read the case. The owner includes any person possessing or using a boiler as agent of the owner thereof. And any person using a boiler to have hired or obtained a loan from the owner thereof. Correct, sir? And now, what you can come to section 12 again.
Yes. Well,
Owner was the cultivation of the boiler.
yes.
And if alteration no structural alteration, addition or renewal shall be made in or to any boiler registered under this act unless such alteration, addition or renewal has been sanctioned in writing by the chief inspector.
Yes.
Then provided. And now that it has to be seen to be satisfied that the owner or that anyone affected by the owner has done section 12 in a way so as to attack section 24C. And there is nothing on record. On the contrary, this form B says that so and so the Pingle is the owner. By looking into all these things.
Pingle is the real owner.
No,
there is no dispute about it.
Real owner.
Pingle is the real owner. Where is that page? Which page you have shown? Pingle?
Pingle
Page
57.
57. Yes.
Well, this owner, that Pingle, he is an employee of Coca-Cola Limited. And looking at the definition and everything, he has been given as an owner.
Yes.
It is not a, it's a company.
Yes.
It's a company with color. It is not, there is no owner of a company otherwise than the shareholders. So looking at the entire the wholesomeness of the statute, Pingle has been shown to be owner. And if Pingle has been shown to be owner, this is the genesis for the purpose of filing the complaint. This is the complaint at page 46.
46, huh? He is 46.
Yes.
Yes. Important. Let us see it. Come to page 48.
Right?
48.
It's I don't know.
Yes. Yes.
In column number 3, sanction is next, if any. When this sanction by the director of the factories of Boilers, Orissa, site is that I showed you what you at page 73.
Yes.
Which is not a record of section 26. And then violation section 12. And clause 2.
What is the stage now? Cognizance.
Only cognizance. Allotment of kind see clause 2.
Yes.
At page 46.
Yes.
Mohan Singh, owner. But an inquiry, everything done before launching of the prosecution. And the report submitted by them shows that Mr. Pingle is the owner. Under what circumstances will a non-cigarette insurance owner hear the complaint? And also the kindly see, law is so well set that there has to be a specific agreement with regard to the participation of a particular company, personnel in the commissioner's office. And the document, I think that asked me to come to page 48. I come to page 48 now.
Yes.
For a brief fact of the case. Hindustan Coca-Cola beverages are from French, and let me skip over that. Again, second pair. During investigation, it was learned that the billet varying between 10 o'clock to 2 o'clock position between flute plate and reversal chamber pump plate had opened up. The sketch of which is shown as Annexure B. The flute plate, this is what with regard to the technicalities. Then document sees the technical opinion on possibilities of the failure.
Yes.
Next page, nothing with regard to whether the petitioner was either interested or in the help other than legal. Then page 50. The nature of the accident. The following damages were caused so and so, all the factors. Water starvation accompanied by excess heat liberated from the solid fuel resulted into steady overheating of the boiler pressure part. Then next page, violation. Before modification of the external furnace, the boiler owner had not correctly calculated the requirement. That's all.
Yes.
But where is my role? And what will I say?
Yes. Give me.
Proceed the but summoning the accused is a serious matter. But AIA 1998 Supreme Court page 1 to 8.
Yes.
What comes to page 28,
28, eh?
Page 28.
Para?
Sorry, I'm so sorry. Page 28.
Yes. Yes.
Summoning of an accused in a criminal case is a serious matter. Criminal law cannot be set into motion as a matter of course. It is not that the complainant has to bring only 2 witnesses to support his allegations in the complaint to have the criminal law set into motion.
Yes.
The order of cognizance, the order to magistrate, summoning the accused must reflect that he has applied his mind to the
Yes,
fact
Pepsi food is commonly cited.
Yes.
Yes.
That is not done by taking cognizance. Then the second question that is application of mind
Please give that.
while taking cognizance. That is correct.
Yes.
That is what the judgment.
Para?
Muhammad Government versus Qasim Muhammad.
Para?
Paragraph 21 and 23. The extensive reference to a case law clearly show that cognizance of an offence or complaint is taken for the purpose of making process to the accused. Since it is the process of taking judicial notice of certain facts which constitute an offence, there has to be application of mind as to whether the allegations in the complaint, when considered along with statements recorded or the inquiry conducted thereon. But here the inquiry is at page 57. Would constitute violation of law so as to cause a person to appear before the court. It is not a mechanical process of matter force.
So there is a 202 should be followed. That's what the.
Yes. Then, the next update is correct with regard to.
Same principle. Principle is same.
Yes. And with regard to
It is not a casual work. Application of mind is required. 202 procedure has to be followed. All these things. These are the common.
That principle is very well.
This is the common principle. The first principle.
The next one is that AIR 2012 2798.
Yes.
2795. Paragraph 43.
Yes. Yes. You highlight those things and give me. Huh? Highlight those things.
This advantage is regard to, there has to be specific allegation.
Yes.
That is here in the head of affairs of the government. Then the fourth submission is that the pleading has to be specific, the role played by the accused. In this kind of cases, it is not there. And the fifth one is improper sound. Now these are the
Judgment should be.
and also one thing I just want to point out that the power of attorney can run it very short. Not to kindly come to page 82.
Then. Yeah, 82. Yeah.
It is effective from first of affiliated to Malay.
Yes.
Penalty effective from first of January 2010.
Yes.
And shall remain in force up to 30th July, June 2010. For a period of 6 months. But here, admittedly, the alterations have happened in February 2009. And the complaint is December 2010.
Yes.
And my joining is in September 2009.
This would be appreciation of the documents at this stage. Again, then I have to, veracity of these document, everything has to be gone into.
But that is not me sure that. I had not learned much on that. I just wanted to read.
Yes.
He was rather creating this.
And this document is relied by you only.
That's to show that what is what.
4/2/2010.
Yes.
The date of execution of power part.
Incident?
Incident 25th June.
25th June?
June 2010.
2010.
And it is force up to 30th June 2010.
Has to make a genuine submission for due respect for that. Yes, the accident occurred in 2010. Section 12 is not accident. Section 12 is alteration. So that is the incident. Because here 24C vis-a-vis section 12.
No, incident is not alteration. Incident is alteration lead to the accident. Lead to the accident. Had there been no accident, there was no incident. Mere alteration is not the offense. Offense is the alteration leads to the accident.
They say section 12. But I have to go by what they say and section 12.
Suppose, imagine a situation if the alteration has taken place in 2006, suppose 2006. Nothing happens. And the incident takes place in 2010. The incident is the date reckoned from that day.
Then section 12 will not be attracted. Then what will be attracted to the other provisions? So section 12. Yet specifically, section 12 has been attracted because alteration has been done false alterations. And the false alteration given rise to the text.
I am wondering.
Also looks at the section itself.
No. The section itself. See, I can't help it, but the section itself, according to me, is little, surprising. Just see, if the alteration, a structural alteration is done by the supervision of the competent authority, sanction is not required. It should have been reversed.
I am grateful to my if there is a structural of alteration on the supervision of the authorities, then not to again see section 12.
Who will be? Suppose a alteration has taken place with due care and supervision of the competent authority, and thereafter also incident happens. Then who is responsible? The competent authority who is supervised, or the person who is carried out? I read it. I am just wondering. Yes.
No structural alteration, addition or renewal shall be made in or to any boiler registered under this Act, unless such alteration, addition or renewal has been checked in writing by the Chief Inspector. Well, this sanction and sanction number 26 are different. Here,
That's sanction for prosecution.
yes, that is sanction of prosecution. That is sanction for the purpose of.
Sanction for, then for read the proviso.
That. No such sanction is required. Sanction as has been stated in the main section, main provision.
No, read the sentence.
Here, no such
Go.
sanction is required when the structural infraction. Additional revenue is made under the supervision of the competent person. So that means chief inspector sanction is required for the purpose of arbitration. If there is a proper person to look after, then chief inspector sanction is not required for the mere alteration. But section 26 is the sanction for prosecution. Where lies the difference?
Do you have any judgment to that?
Pardon?
Do you have any judgment?
Well, right now, of course, I don't have, but I am just reading the section. And not can I see section 26 again?
Yeah, I can understand. See, the expression used here, sanction, it should have been permission or that sort of.
Of course, section 16, 26. There are two sections are operating on two different.
I understand it. Now I understand it. Not that.
Now I'm saying that the sentence starts with no prosecution. No prosecution for an offence made and punishable by or under this act shall be instituted except within 24 months. So there is the commission of the offence, and no such prosecution shall be instituted without previous sanction of chief inspector. But this section 26 speaks of the prosecution, section 12 speaks of the alteration.
See, that sanction is a different sanction also.
Yes.
May I tell you? That
I understood it.
that chief inspector, my learned senior is harping on the chief sanction should be from the chief inspector. By that time, when the incident occurred, in the year 2004, that chief inspector power has been given to the director of boiler, to the page 17. That is gazetted Odisha government labor and employment resolution.
17.
Page 17 of our counter. The Lordship kindly see. Chief Inspector of Factory Boiler changed the designation Director of a Factory Boiler.
17, huh?
Yes. Counter rapid.
Yes.
Page 17. It is resolution dated 9th July 2004, man.
Yes. Where do you say that?
That is just below.
Where-
Serial number, designation, existing post, and change the designation. Yes, it's counter. Counter rapid filed by the state assistant director.
Is the counter there on the record? It is there on record. I'm referring to.
Yes.
You give a counter. Where? Yes.
That is chief inspector.
Okay,
Your Lordship.
I understood it. You give
Yes.
a counter if you want to say anything. You give it. Yeah.
Yes.
Yes. The rest of the matter, I'll take it up. You can find a written note if you want.
Again.
You can find a written note.
So this can counter the court for the actually the provision made delegate.
Yes.
Delegate designation
Yes.
change. Designation change. Designation. Only designation change.
So chief inspector sanction obtained from the director. It is 2011 matter.
2011 matter. Now you say that counter I have not reported. It is filed. It is there on record.
Kindly see the article 13.3 of the Constitution. That's the article 13.3 of the Constitution.
Why in a cognizance matter? Where are you taking me? Constitution and all.
That's simple. Let's see the article 13.3 of the Constitution. What it is? It's a resolution. It is
No,
not.
previous page.
Now, the child of the
Tar ago page.
child of the
Tar ago page.
The resolution
Where is that?
at page 16 and 17. That's it, page 17, page 16 of the Labor Department, Current Department. Page 17 of the Labor Department.
Yes.
Document just sees after 30 days contribute. Whether resolution is the law or not.
Yes.
Lordship, kindly page 16.
1 minute. Yes.
Constitution is the law.
Lordship,
But it says, law includes ordinance, order, bylaw, rule, regulation, notification, customer users having the territory of the India.
Yes.
It's a resolution.
Notification.
No,
In
it's
the form
a,
of notification.
it's a resolution, not notification alert.
Yes. Anything else?
That is not, unless the act is amended or act may not, in fact, permit such things. It can be that.
Yes. Page 18.
Page 18.
Labor and Employment Department notification. Dated. Then 13, how will it bring 13? Article 13.
But here also notification.
See, in a cognizance matter, you take it to Constitution when you don't have a case.
that notification.
Very simple. When you
That
don't
is-
get anything, you go to Constitution.
Your Lordship, Your Lordship, in that,
It's a clear case up to 13 now, 13 complied. Its designation is changed. देखो तो you get the time. You can file a small note. Take. No, I am reserving it. You get me. I spent more than 45 minutes. I am allowing you if need. I hear you.
Yes.
You can hear, but file a written note.
Let's see, the petitioners are granted bail in ABL appeal number 3607, dated 3425, with a condition that they shall not have any antecedent. Let's see, in para 6. 19, possible.
19, 19.
Let's.
on behalf of Siddhartha Sankar. For that, for the said reason, they are not surrendered. Lordship kindly first half and second half with parity.
Yes,
Lordship some criminal antecedent, 6.
that I can't help you. There is an order, you have to comply that order.
Lordship first hour, second hour and parity.
It is already there. It is already there. It shall be released on bail, the court says.
Not surrender, surrender hai in hand. 303, re,
See,
30.
para 5, read madam, para 5. Para 5, it says that on surrendering within 3 weeks hence and moving for bail, the petitioner shall be released on bail.
Let's see, para 6.
But there is a condition is that if any antecedent is
Antecedent.
That
found,
I can't help it. No?
having
That I
petitioner
can't
is
help
having
it.
antecedents.
6 antecedent.
You are seeking quashing of the FIR. Madam, petitioner is although seeking quashing of the FIR number 1. However, the responsible for the petitioner submits that he will not press this petition as it says, rather legal right to execute the issue with the appropriate stage of the trial court. She further points out that the petitioner had already approached the court by filing ABPLA number 3592 of 2025. The coordinated bench of this court by the order dated 3/4/2025 passed the following order 5 and 6. She further submits that she would withdraw. She further submits on second that the right to surrender before the court within 2 weeks hence and await the benefit of the order dated shown further. With this liberty, the petitioner is disposed of. Yes.
44.
Notice is sufficient, but nobody has entered appearance. I'll give a date, let us see. Notice on opposite party number 2 and 3 is sufficient. However, none has entered appearance in the interest of justice. Leave to matter approval.
Item 80.
80. Nobody there. Yes.
82. First, kindly, there is a public complaint. Two guardian affairs and complaint order taken. Ultimately, in Annex 4, sir, case 19, collector inquired into the matter and found that no similarity. First, kindly to page 19.
Yes. Which para?
This is figure of way. This is the matter of procedure of 9.70 non-PDF, right? Interesting described, and it says that keeping in view the order of the High Court, in this case, it is order that the clocking of sound be refunded the state proceeds of how he refunded state proceeds to. This is all things he has already cleared. On the basis of
But the offense has already been committed. Merely clearing the dues doesn't vanish the what you call the crime which you have committed. No, Essential Commodity Act and penal offences are also there. 420, 272, 439. Sorry, 34 IPC. And you can very well argue Section 7 of the EC Act may not be made out in view of the report of the collector. But how to get rid of this 420, 272, 34? On the basis of this collector's report, you can very well argue Section 7 is not made out. But 420 and all those things will remain. Better do one thing. I will give you liberty, you move an application before trial court, argue this point. At the stage of framing of charge. Yes. Madam, petitioner is assailing the order dated. Order dated 17/2/2013. Was there any stay order operating? Because see, Cognizance was taken in 2013. What has happened today?
That is the decision and a distributed file, and that the interim order earlier granted on 25/11/2013.
Charge has been framed or not?
That has not been.
Telling me the order dated 17/2/2013, passed by Leonard JMFC, Chandawali. 17. Where is that order? Order? Yes, I got it. Whereby the cognizance of offences control under section 272, 420, 34 IPC.
272 is madam, because there is the adulterate rice. The rice was.
And essential community act, cognizance is also not taken. Follow-up report has been taken, has been taken. The present petition has been pending since 2013. An interim order dated 25/11/2013 has been continued. Subsequently, the matter was dismissed for non-prosecution on 12/7/2020, which was then on the application of the petitioner. The petition has been restored by the order dated 24/9/2024. Next program. The Learned Counsel for the petitioner taking me to annexure 4 to this petition. That is the report of the collector, district collector, dated 4/5/2013. Submits that the collector has there was a in-house inquiry conducted by the collector, and he has submitted a report. Thereby, he submitted a report. As per the report, the victim persons have already deposited the alleged fraudulent amount, hence no sense if the collector's report taken into consideration. At the stage of cognizance, I will not petition. However, the liberty is granted to the petitioner to move especially the application of the trial court. In that regard, if such application is moved, the same to be considered in its merits. Yes, liberty.
There is a order, my lord. And whether there is adulterate or not, it's the report. The Lord is kind of clear. There is a order, my lord, it's an order.
51. Yes.
Whether that rice is adulterate or not, 272 cognizance is there. And the report is received examination report, simple rice.
I am not saying anything. I'm not saying anything. Yes. 52.
52, my lord, I am appearing for the accused, my lord. Here, my lord, Prabhakar Samanta is the informant. Petitioner counsel is not there. Agreement is they want to release that bank guarantee which we have taken up. Because, my lord, we were here, that is a energy, my lord, it's a biodiesel product. So they used to construct farms. So they entered into an agreement, but they violated the agreement. We took away the bank guarantee. Now they want to release that bank guarantee. So they have filed a 457 application. It was rejected. And now they have come before this court, my lord. There is an agreement and arbitration clause is there, my lord. Page 51, my lord, may I have a glance? 51? Page 51.
Yes.
Governing law and jurisdiction, my lord. My lord, kindly see his signature over here and my signature. Right, for my Energy and Prabhakar Samanta. In case of any dispute arising, governing law and jurisdiction, italic 2. In case of any dispute arising out of or in relation to this agreement, shall so far as.
Arbitration. Arbitration.
Arbitration, Jibo. So I'm going to FIR file, but that FIR is a different, it's a criminal angle, it will take its own. But release of bank guarantee and all these disputes are part of this agreement. So how come they can file a 457 application and try to release it?
Is there any order in that 457?
Yes, ma'am.
Rejected by the both the courts.
Both the courts.
Rejected?
Yes, rejected.
You are the complainant, you say?
No. I am the accused.
You say I am the complainant?
No. I am the accused.
Okay. Your application and 457 rejected?
No, not my application.
It's not filed, the
The complainant has filed 457 application.
for release of that 30 lakhs, man.
30 lakhs, not
That
going.
court has not considered.
Let us see the order. Let us see the order.
Yes, right.
Let us see the order.
That is fair, your lordship kindly will not fails. There's nothing.
Page.
Application filed by the petitioner.
50.
Who is the petitioner? Prabhakar Samanta.
Okay.
You file the petition.
No, not me, man.
Prabhakar Samanta is filed.
You are the Prabhakar Samanta, right?
No, man. Prabhakar Samantara is the petitioner. I am not the petitioner. He is not there, man. Petitioner counsel is not there. I am for the accused, man. He is the informant.
You are for opposite party. No?
Yes, no. He has also not made me.
Opposite party is not a party.
Not a party also.
Then for whom you are appearing?
My lord, I am appearing for the company because he has made all the allegation against the company.
You are not a party to the proceeding.
No,
you
man.
are appearing, arguing. I thought you are petitioner.
I know only state of.
There is no, except state, there is no other party.
Yes, my lord. That is also another problem.
Then that is the only problem. I have been hearing you thinking that you are
My
petitioner.
lord, only that, my lord, I am adding this court to this.
You have to be made party, then only
Yes,
you can
my-
appear.
But this
Who is for petitioner?
petitioner is absent, my lord.
You are arguing, I thought you are for
No,
petitioner.
my lord, because the entire thing is against me, my lord.
Yes, sir. All right, but unless you are a party,
Yes, ma'am.
move an application for
No, I'll
intervention.
move an application. I'll move.
Then I can allow that and I hear you.
My,
If you are agreed by this order,
no, I am not agreed.
Then-
I am not agreed, my lord. What has happened?
it
The
was rejected.
petitioner
Petitioner move application 457,
Seven.
which was rejected, confirmed by the regional court.
Yes, my lord.
How are you agreed with that?
I am not agreed.
Then-
I am saying that, my lord, when this such an application is also not maintainable, 457, when there is an agreement, when there is an arbitration clause.
It is not allowed, why do you worry?
Yes, ma'am.
It's not allowed. If had it been allowed, then I can understand.
My lord.
Arbitration, whatever you take. It is rejected.
My lord.
And if the petitioner is agreed by that, petitioner is not here. Is there any interim order? No.
No.
There can't be an interim order. None of fees for the petitioner. It's a matter of 4 weeks. Not really.
For us.
Yes. 53. You move application and
Yeah,
get
go to court.
8 years.
Application 5 like
There is a content petition also.
Contempt of the whole. There is no contempt, man. The court order is violated. What contempt is, requisite file for nothing for that reason also, you got seen noting my analysis. Noting requisite not filed for that reason, so notice was notice.
What is the contempt? Let us see.
Contempt
Unnecessary.
is kindly see.
Is arranging what?
The prayer is publication number 16-019/2019. And in that 16, that order is annexed, page 8 euros.
It is चलची
Till 1 month from today, the appointed partner for the guy.
52 no 51 no 52. But what the content petition, see why the content is pending? What content? What content?
My lord,
The 457 application is rejected
Not to encash or transfer to any to any.
and you don't file the requisites also.
Contempt.
No, these are content not prescribed. That's better idea. But he has argued for you in your option. He's already argued. Yes. Contempt not prescribed. Next. If you argue like this, your name will come obviously. And now you are holding a position, then your name has to come.
No, nothing. Good.
But file intervention. You want to be heard in this.
Again.
Yes, next.
Next treatment. Proper.
ठीक है पूरे चौधरी पर ठीक ओके कंटेम्प्ट है ठीक है yes and there is a Mr. Patnaik, there is a recent judgment of mine just see in this slide 457. You can just check that judgment, that will help you. A recent judgment, just check it out. Yes.
No, they do sanction.
You take the number and yes, 52, 53, yes. Yes, sir. You have not filed.
Not filed those.
You filed it. File for okay. Pursuant to the order dated 12/3/2025, 25, Mr. Mohanty hands up for the additional document in court along with the relevant these updates and so forth. Let him file the same in the registry. Please the matter for okay. File. Yes.
54. Losses also concurrent because at the times.
Just see the additional document with me. Everything is there.
This is the point. I do not want to.
There is no in the CRPC. It is the unknown to the law that the preliminary judgment. Once the police
It can be done. It can be done. Yes. Successful. Opposite side. Fall. I can dispose it up.
The conditions also mentioned in the report.
Call in. The other side, lawyer. Okay, I'll pass it. 55.
Second indicates a selection for the fraction. Second domestic violence case after 4 years.
What happened to mediation? Failed, huh? Mediation failed.
Taxi. Mediation report taxi.
Failed, huh?
My husband not appear in the mediation center. In the absence of a husband, that mediation was failed. Lordship kindly find out 11/6/2022 the report of a mediation center.
Yes, you are appealing for husband.
Yes, sir.
You didn't participate in, you didn't participate in the mediation. No, report is otherwise you did not participate. But the petitioner number 3, Rajesh Singh, did not personally appear before the mediation center as well as today. Earlier also you did not appear. That's the report. I have to go by the report. Where are you staying? That's the reason you don't want to.
And subsequently, recently, it has been confirmed by this Honorable Court. This Honorable Court has recently confirmed.
When?
It has filed 45 number of criminal cases that it was like. Whenever he comes to Orissa.
Yes. Yes.
Here, in the year 2017, first domestic violence case was instituted. So I am facing the trial. There was a maintenance order along with the house rent allowances. House rent allowances 10,000 and 45,000 maintenance, or total 35,000 I was paying.
Yeah, but now have you seen? You are.
My lord, I will challenge it in the Supreme Court.
You can challenge it, but see, the mediation has taken place in June 2024.
My lord.
That time the divorce proceeding was pending. Now
Pending.
divorce has been granted. In the light of this development,
My lord.
why don't you participate and settle now?
My lord, I am participating.
What are you seeking? What are your conditions?
My lord, I want to stay with my husband.
That can't be now because of this.
Well, that's
That
why
can't be.
that's
Said
why
about staying together.
that's
Now
why
you
that's
tell
why
the
I
other
will
condition.
challenge in the Supreme Court, Honorable Supreme Court, my lord.
That is your right. I am not.
That is within limitation. I will file it.
You file it after SLP dismiss. Let the interim order continue. Mr.
Farooq Shah.
Date Pradhan Counsel for the petitioner has brought to the notice of this court that on 19/3/2025 for the appeal filed by the opposite party. Yeah. Mata number 315 of 2023 has been turned down and the divorce granted by the court below has been confirmed, na?
Confirmed.
Has been confirmed by the division bench of this court. This court. Then counsel for the opposing party submits that on the second submits that they would be challenging the judgment of the division bench dated 19/3/2025. In view of the recent development, means the matter after 3 weeks, the interim order pass earlier shall continue. Yes.
56.
Pending the court of law and which is selected. In this case, my petitioner has rejected and simply only people belonging have been placed for that.
Yes.
In spite of notice of service, the opposite party might or rather they filed in order to have the petition filed another case before the law and which is solid good. Criminal mistake number 47 by 40 on the second. 53 and available 53.
What happened to, is there any proceeding pending under 498A?
City mail, the law and have the allowed the case as expert in that and directed the petitioner to pay the 3 lakhs plus formality. But expect of that, the petitioner offered to the wife, we would take in 3 lakhs. plus-
Where is that expert order?
It's one page 21. Judgment dated 24/6/2021.
Yes.
Neither they filed any case before the next day and the petition before this case. This honorable consolidated 12/21 direct stay of order proceeding and subject to payment of 3 lakhs requires subject to payment
Yes.
subject to payment of 3 lakhs requires.
Yes.
Lord, they have filed affidavit as per noting, and not served a copy of the same.
Shall I send it to mediation and decide it?
Already married and if a child, say, not opposing party, why you married to another person, you get back to child.
So it's more of a reason that you setting this.
But I will take instructions.
What I am sending it to mediation center is.
Yes.
Yes, do it. The current petition is arising out of which mediation center? That's good. Where shall I send it?
High Court mediation, sir.
I think the petition is seeking questions of party being criminal miss case number 47 of 2020 pending before the court of the AMC Salibu. Notice was issued to the petitioner by the order dated 2/12/2021. Persons thereto for the opposite party. This next paragraph, the dispute is arising out of therefore there is a scope of out of court settlement. And the petition, the counsel setting from the parties have also been similarly. Therefore, the matter is referred to the High Court mediation report. This matter is also entering order to continue. Yes. Participate, let us see if something. Yes.
57.
Let's take
Eight.
We have been also, will be, we all been offered against the parents who are more than 75, 78 years. The demand of dowry paid also 480 days. They were in also inquiry, but also carry out the acts of page 30. Page 30. Yes. Committee was inquired into the matter, said that there are no demand of dowry. And also, this festival opened that.
Which committee is this? Family Welfare Committee?
No, sir. Yes. Family Welfare Committee, Bhubaneswar, they inquired into the matter. And both my son and Brothel are staying in UK. Another son is staying in USA. The son who is staying in UK, he is not looking after me. And because of pendency of these cases, both the old parents are unable to go to the second son and in USA. That's why hospital last hospital director, they are avoiding notice in fact of several occasions.
And I have already obtained instruction from the local IAC. Now the informant OP2 is staying in London, your lordship. Therefore, notice could not be served, your lordship. That report has been supplied by the IAC, Info City Police Station, lordship.
So,
and this is the mention, lordship. Last 7 years.
what is this? He has filed a case against the elderly parent-in-laws and left for London. And these people will keep on suffering.
Lordship, there is a material signature present petition also. I have so. And there is the material signature so far present petition is concerned regarding torture and demand of dowry, and after deliver of a girl child, thereafter the present petitioners are abused in slang language. Why you are delivered a girl child? That is there, your lordship. I will satisfy that. That whether the allegation is omnibus or general, here is a case is specifically has mentioned that after she gave birth to child, female child, thereafter the parents-in-laws have started abuse.
For me.
Yes, I have given a statement, the independent statement, and so also.
Okay. Let us come to the charge sheet. Let us come to the charge sheet.
Yes, sir.
Where is the husband? Husband is also in UK.
Both my son and daughter both are in UK. Lost their file, went there.
They are not responding, not coming.
Very, and one more very,
Your son is also an accused.
No, no, no,
Son is not accused.
no, only parent. That's interesting. Now.
and a very interesting may happen. Now, son has stated against his parents, your lordship. It's very unfortunate, your lordship. Might have the incident.
I think heavy cost should be imposed against both of them.
I'm very appreciative.
Both of them are mixed up now, suffering.
Very unfortunate. The son has stated against his parents, your lordship.
Instance of opposite party. Opposite party.
May I read statement of that, your lordship?
Give it out. See the age of the parents.
I'm aware of the age, your lordship, but the facts remain there is the materials. Therefore, your lordship, and brings the notice of the court that how the daughter-in-law and her husband stated against the present petition, lordship. Her husband, puota kon koichi, lordship, lordship. ମୋର ଯେତେବେଳେ ଗୋଟିଏ ଝିଅ ଜନ୍ମ ହେଲା ସେତେବେଳେ ମୋ ବାପା ଏବଂ ମା ଝିଅଟି ଜନ୍ମ ଦେଇଥିବାରୁ ତାକୁ ହତାଦାର ମାନେ ତାର ୱାଇଫକୁ ହତାଦାର କରୁଥିଲେ ଏବଂ ମୋ ସ୍ତ୍ରୀକୁ ସେଇ ଦିନଠାରୁ ତାଙ୍କୁ ମାନସିକ ଏବଂ ଶାରୀରିକ ଯନ୍ତ୍ରଣା ଦେଇ ଆସୁଥିଲେ that is there and independent statement independent witness also stated said
Who all are the independent?
here is the son my husband of the informant
He is not independent.
No, I am not saying
Anyone else?
Anyone else, lordship. Sandharani Behera, lordship. That is independent
Who is
witness.
he?
He is also neighbor, lordship. He is stated in the lordship. That is there. After delivered a girl child.
How many children you have?
Two sons only.
No.
Is there any property dispute between two sons?
Property taking 2018 FIR ଦେଇକି ପଳେଇଲେ 2025 ହେଲା and then Deepo Bhai, both old parents are now suffering. The other son is asking them to come back. Yes, but visa is not granted because of pendency of this 498 case.
The statement is very specific, not an omnibus.
Please the report.
This is Sandharani. I have given the Sandharani by marking highlighter.
No, give the report. Forget about that. Yes, where is that report? Service report.
Instruction. I have flag mark, lordship. Instruction. Last year, lordship. Instruction. Red flag, lordship.
Petitioners are since of opposite party number 2. FIR number so and so came to be registered against the petitioners. क्या हो रहा है भाई? What is happening? So and so came to be registered against the petitioner. The petitioner number 1 will be father-in-law, whereas petitioner number 2 is the mother-in-law of the opposite party number 2. In this case, the opposite party number 2 is the daughter-in-law petitioner. Find the registered against the petitioners. Petitioners. The husband of the opposite party number 2 is not a party. Not making. Rather, he has been cited as a witness who has reported his own parents. The allegation is the petitioners, right? What's it mean? The allegation of the business is shown. Notice was issued to the petitioner, a opposite party. White order details. The party by order dated 6/9/2020. The notice could not be served, therefore, this court directed this court by order dated 29/1/2025, directed the IIC Bhubaneswar Info City Police Station to serve the party number 2. The IIC Info City Police Station has published the report dated 8/2/2025 with the result. It is definite from the report that now along residing with the husband, his own, her own husband, no?
Yes.
Husband. Petitioners are the senior citizens. They have been undergoing the ordeal of what is the stage? Stage, cognizance.
Cognizance will taken case of year 2008, to 2022, cognizance taken. Because they are staying at home, no proceeding is going on.
Right. The ordeal of the criminal prosecution initiated by the opposite party in the year 2018. The charge was also filed by 2022 and cognizance has been taken by the court below by the order to pay 10/1/2022 for evidence commission of offence under section 498A, 320 and 34 IPC. 34 IPC, but because of the regular absence of the informant of the opposite party, the case is not open. At this stage, the petitioners have approached this court for seeking quashing of the criminal case pending against them. Then the criminal approach the charge sheet what have you filed this judgment? What judgment you do? And it's a 6.
Right. So the civil case is looking.
Which paragraph?
No, 22, page 43.
42, 22.
Paragraph 22, page 43.
That the opposite party has only years and general release against the petitioner. Petitioners that is the laws that after the part of the part of surprisingly, the common case the son of the petitioners that is the wife of the admin of the party. Has also made omnibus the petition stating that the petitioners have been free from mental harassing the opposite party. Both the opposite party and the present petitions are senior citizens and suffering the ordeal of the criminal process. Mr. Samantra, the counsel of the petitioner, relied upon a judgment of Supreme Court in criminality number 195 of 2022. Strongly he has drawn my attention to para 22.
Yes.
Para 22. Only for 22. No, what is the ratio?
Ratio is that not because all these cases.
Which paragraph ratio you tell me?
Ratio. In fact,
Para 12 and 22. Para 12 and 22. He further submits that on the basis of fault from omnibus allegation, devoid of the material on record, the material on record, the petitioner cannot be allowed to suffer, the criminal prosecution, particularly when the informant is not the resident of India. Repeated attempt made by the petitioner to serve opposite party held no reason. Therefore, through the IAC of police station where the fire accident registered, attempts were made for observing her. However, she has not responded to it. In these circumstances, continuation of the criminal proceeding on the basis of omnibus general liability against the petitioner by their daughter-in-law for the commission of offense under section 498 IPC, which we futile exercise and rather futile exercise. Therefore, this case directly caught by the judgment, dancing so on so on and cost. How to be better? Yes.
The petitioner challenges the order of cognizance dated 19/7/2022 passed by the Honorable STGMS Cutter, thereby taking cognizance of offence under Section 403 of Indian Penal Code. The case of complaint, this present petitioner had taken a hand loan of ₹80,000 from the complainant. They have did not return. So it's not a case made out against 403 of Indian Penal Code. It's completely civil in nature.
Yes. What are you challenging then?
Order of cognizance.
Yes.
Section 403 of Indian Penal Code.
You say 403 is not made out.
Yes, ma'am. We had taken a hand loan of ₹80,000 from the complainant.
Let us see the allegation.
Yeah.
Let us see the allegation. Hello, Das. Yes. Complaint.
Complaint petition is Annex 1, page 8.
Service incomplete. Siddharth Kumar sir. What happened to that car?
Car belongs to me, petitioner. Car belongs to petitioner. Car belongs to petitioner.
No, just see the allegations are.
Yes, ma'am. Last you kindly see the page 15, the initial statement of the complaint,
Yes, page 15. I'm there.
Yes, starting page 15,
I'm reading that only. 83rd page.
Yes, ma'am.
How much you have taken by the way?
80,000, allegation 80,000.
Give it.
There is already pay
You
my
said that give me 80,000 rupees and
Al-
he gave you, and
already-
you said that I'll sell the car and pay you back.
This is not case of 403, my lord. This is
Whatever.
complete civil nature, my lord.
Oh, it's all right, but pay 80,000 and finish it.
Because this my
Again, you want him to file a suit for this.
already paid, my lord. Due
Case
to
may
some-
not be made
due to
out.
Some
Show me where have you paid. Show me something. Show me on record something you have paid.
next week, next week.
I'll send it to mediation. Go to mediation and pay whatever. Right on. The notice was issued to opposite the petitioner. In this petition, which is in person up to the order dated 19/7/2022, passed by HGM S. Cutter in 1CC case number 356 of 2022, whereby wherein the cognizance order, whereby cognizance of offence punishable under section 403 IPC has been taken against the petitioner. The complaint case has been filed by the opposite party number one. The reading of the complaint, the allegation of the petitioner is that the petitioner had taken rupees 80,000 from the opposite party, they apparently know, and promised the same to be paid after selling the car. The petitioner has not paid the money to the opposite party, hence the complaint case. Regarding notice was issued to the opposite party by the order dated 20/12/2022. Mr. So entered appearance on behalf of opposite party, however, none appeared regarding it to the nature of offense, nature of litigation with the petitioner, and the fact that the case is emanating from a transaction, monetary transaction. Now, I feel it appropriate to send the matter to which mediation center? Which mediation center I will send it? High Court.
High Court.
High Court or Sridhar High Court. Complaint case could be pending as well.
Cutter, SDGM Cutter.
District Court. District Court. Coordinators which notice awaiting mediation report, please the matter of.
There is a judgment of appeals court, my lord.
Huh?
There is a judgment of appeals court, my lord. Mere inability to accuse return loan.
All right, pay the money again. You will ask him to file a suit. He'll file a suit, another burden on the court. Pay the money, whatever. 60. Entry mode to continue. No? Entry mode to continue.
Understood, requesting your RC that take it any other since the file was misplayed during the shifting of chamber and file could not be traced out. My lord. Last week it was listed on Friday 11th. That day also I approached your lordship. Your lordship may take it any other day so that in between we get.
Why file you have misplaced?
In just before 2 to 3 months, our chamber was shifted. That is why the file was misplaced.
No, that is not the reason.
Yes,
The
ma'am.
reason is the entry model.
No, my lord.
Yes.
No. Your lordship may fix any other day. So that.
Reason is entry model. If
No.
there would not have been entry model, file would have been there in your office.
No.
Now entry model is there, so file obviously is bound.
It's true fact, my lord.
How much time will you take?
7 days. Only.
I'll give 1 week. Wait. He has misplaced file. He wants to construct some file. And say it's 1 week. We see matter. We have 25th. We see matter on 25th. The entry model till 25th. 25th April. Till 25th. Thereafter I'll not continue. It made clear that the matter cannot be withdrawn on the dictated appeal. Yes. 61. Your written note is yes.
Nothing can see base phase two. Small lecture. That's it. Like continue version there. All the as per the allegation of the conviction, they reference searching. Then if you can see 21 2 plus 18 2 number 2. That version. There people try a comparison. The interest next day 21 2 check here. Petition of by email, but check here. And it remains with the account. This is complete. And complete again, nothing can have to buy now. After 28 plus I have given the return. That depends on the statement of the application. On 20, can have to buy.
How is that beautiful?
Because you are seeing that in the industry, single people. But they presented by the company land. Then here. So, and if you look at the entire scenario, there is no occasion for bouncing of the check with the instruction of us. So, at least, based on that, what I have to
Show me this. Show me this from where you got it. Here, check here.
let's look at the process per page. 17 answer 160.
What did you check amount?
Check amount of 161.
161,000 for big. 17. Yes.
It is money account. 21 222. Take university and it transfer to the account of company 31 us 161,000. Check, I said 31 us.
Debit.
Plus. Then also can come to. And test complete.
I will be paying for the other side.
Last it's not there. All of those it's not there. Now it's last ahead. And second price 25.
20.
25. On 21 version, the amount of sell the ones not less 600 transfer to Jacob. And it remained with 23. As second hard version, and it is compared to on 40 sheet, it remained of 4 days. And it is come to my account.
How will it come to your account once in your account? How has it come to your No, how can it be possible? It's not possible at all. You will check it rightly, wrongly here. Go to somebody's account. Again, it will come back.
Again, it is not backwards. Because the signal that they got, they have given the expansion. Like they have given the explanation. Because the signal that they
Once it is debited from your account, credited to the account of someone else. How from that account it will again be debited? You show me the corresponding entry in his account.
I just want to say that is request to be made.
No, which one? 20? Where is that her account? Yes, where is that? 20? 20? No. Entry number? 88.
On 21, at 22, 10 21. 22, but at 21, the deposit service is not organization.
This is what is written, I don't, nobody can read it. What is written there in that entry? Show me if I can read from your. Please, what is the? Twenty. What is it written here? Merely the sake of amount, the resemblance. No, 21 if it is debited from your account. 21, it should have been credited in their account. Where is that? No, that is 25. Yes, yes. Compared to who's it? Yeah. How can it be? I don't know. Once it is credited in somebody's account, how it will be debited without the bank? That is the reason. There are things it has to be gone into in the trial only. I can't go into all these things. Cognizance is taken because Cognizance is taken because statutory notice was given to you show me that you have not received the statutory notice. Then why have you not replied back? You have told all the things. Therefore, 139 operates against it. So therefore, wait for that stage. Wait for that stage. That is your case. Wait for that stage. I'm not declaring any petition. I'm preaching cognizance of. Very clearly, when you make a statement, separation of material. That is the reason 138 is there. Notice is given to you. Then you have to answer and say that these are the material you have separate, so therefore you can't proceed as a first opportunity, not a mistake. 139.
I have private with the IRS. I'm not on the IRS. If that is so that 139, I can extend the IRS.
You have to travel little more also.
Little more also.
And face the trial.
Lordship, no lordship, because I am scrutinizing lordship. Hadn't been lordship, can see this is 130 gives complete lordship enter to the complainant to file the complaint.
Show me what are the judgment you are relying upon. We are not going to waste so much of time. That day also I heard you about 20 minutes. Yes, yes.
No,
I remember. I
minutes and lordship because the lordship
I
told me to prepare a written note.
Yes.
I have prepared a lordship.
Very good that you.
Case.
Let us see the judgment. Let us come.
Lordship, can you refer one by one?
First, Manoj, go ahead. Please, Para.
Ask lordship, legal points I have taken lordship.
I saw it.
Let's come to B lordship.
Yes.
Lordship, I have taken a ground check dishonored for signature mismatch, not insufficient funds.
You just tell me how will you get out of 139
Lordship, I.
and 114, 118.
139, always subject matter of trials.
Then,
But I am here of the order of challenge under convenience.
so you can't do that.
Either my humble
It,
submission.
the see, irrebuttable presumption operates against you. Burden shifts on you. You have to discharge the burden. As simple as that.
Lordship,
You keep on arguing
in this case, Lordship,
5 days also, nothing will
in this
come.
case, Lordship.
Burden shifts on you. Rebuttable burden.
Apart from 139 Lordship, here Lordship, question of limitation is there. It has not been, Lordship, can you see that two aspects, Lordship? Lordship, can you see, Lordship, can you see? First, he submitted the.
Show me the limitation now.
He, Lordship, can you see the dates, Lordship, then I'm going to.
Yes, yes.
Lordship, can you come to first legal notice around 25/3,
Mhm.
2022. 25/3, 2022,
Yes.
sub legal notice. The cause of action starts from here, Lordship.
Yes.
Lordship, the check deposited on 18, Lordship, is two document. 18/2/22, she presented the check.
See the complaint.
Something like that.
The complaint says,
Lordship.
if I am not wrong, I remember that.
Lordship.
Complaint says, first I gave a notice, that is, 1 minute,
That is
1 minute.
Lordship.
He says, on 25/3/2022, I gave a notice.
Lordship.
You received it and called him and said that please redeposit it.
Lordship.
It will be honored.
It cannot
And
be.
it was redeposited,
It cannot be.
dishonored.
It cannot
And thereafter second notice was issued and the limitation started from there. This is the everment. If I am not wrong, I remember it.
That Lordship is absolutely correct.
Mm.
And I have come prepared only to convince Lordship that part.
yes, yes.
Lordship, can you see? On 18.
You say that the limitation recon from first
Yes,
notice.
yes, Lordship, that is the law of land. Yes, that is the law of land, Lordship. That is the law of land. I can explain, Lordship. Lordship, can you see the check deposited on 18/2/2022?
Which is the cause of action?
Cause of action, Lordship, 18/2/2022, Lordship, of the knowledge of the Lordship.
And why have you?
When he obtained information ban, then the transaction.
Let us come to the complaint.
Lordship.
Let us come to the complaint.
Yes, Lordship. Lordship, in the part, then that's a Lordship.
I read it. I read it. Yes. Yeah.
Go to where preparation to convention, Lordship. Then Lordship will after that I will come to the complaint, Lordship.
Come to page 33, para 3.
Yes,
Read it.
yes, thereafter, Lordship is saying, thereafter, the complaint has issued a statutory legal notice, so is adopted by registered with dated on 25/2022 to correct address of the accused, asking him to pay the check amount of rupees 1,61,000 rupees, only to pay him 15 days from the date of receipt of the notice. But the accused received the said notice and requested the complainant that he would rectify the signature in his bank. Lordship is never, Lordship can see. Once he had it been, he enjoyed for amount for some time. And if the bank is sent a check with endorsement.
If you would have replied to this statutory notice, all these problems could have been solved. Because the presumption could not have been operated against.
But that is
That's the problem.
that is that I had evidence. It is up to a videos. I obtained it without reply. But that's it.
I'll pass your, I'll read everything. Don't worry. I'll deal with each and every judgment you have.
I have come to the enter recent judgments of Supreme Court.
Yeah,
Supreme Court, even if Lordship the recent was good judgment, said, even if Lordship signature differs, I cannot, yes, I can take advantage of that Lordship. I am coming on the public section 138. But the cause of action arises from the date of the issuance of notice. And the date of issuance of notice, Lordship, both the counts Lordship can see. He issued notice Lordship on 25/3/22.
Yes.
Then this complaint petition ought to have been filed within 15 days, within 1 month. So Lordship granted 15 days time. So he proved so much. He in the pretext to file present second time and to avoid limitation, he issued second notice. That is your Lordship 4/5/2020.
See, his complaint is very craftily drafted.
But Lordship is committed mistake, Lordship.
No, it is not counted.
Lordship is
That is
Very crafty.
That is, that's.
He said that on your request,
No, that cannot be.
deposited.
That is common sense. That's it. If that
I will not go by common sense. I'll go by the complaint. Cognizance, only cognizance.
Cognizance is purpose to mind. Because that's it. The cognizance.
Anyway, I'll.
That's one aspect. Had it been disclosed, let's say a person up to should approach become court with clean hands. Had it been the materials before the land court will that he was enjoying the entire amount for some time and the check has been clear. For us, this appraisal could not have been ours. Reason regularship, he has not whispered a single word. The money was transferred to his to her account.
That's the reason the legislator will design the scheme of law to give first opportunity to the accused to wash your hands. When the notice under 138B is given, you wash your hands. That time.
Legislature has given a hand to me, Lordship, to rectify defects, Lordship, by repaying the amount. Because when I, Lordship, the
Okay, I'll pass there.
Another part of the report. Limitation, the second.
I'll deal with that.
Second petition, limitation.
I'll deal.
Second of the.
I'll deal with that, sir. Don't worry.
Ticket based ticket. Otherwise, it will be confused as to how the interest.
No, I'm confused.
Again.
I'll deal with it. Don't worry. It's not so big a matter that you will take so much of time.
No, that's true.
It's a matter of.
But for your Lordship, it is very.
No, it's not for me, for anyone.
What's subject to convince your Lordship? Lordship, can you see page 3? 4.
At the cognizance stage, if somebody argues for such a long time, that itself justify for a trial.
Lordship, in fact, in other states, Lordship.
Cognizance stage, the moment you see, it should be apparent. What?
I have seen.
If it is so much time is required to convince a court, that means there is something to be done. Therefore, the trial.
So that's why I am critic from written or submission.
You are laboring so hard.
The second show was notice.
Yes.
16 I not rotating.
Yes. Yes, I have marked that.
In 15 days, Lordship, he filed complaint of 700 2 months. So it is hopelessly by the law of limitation.
If you count from first day.
If it's a counter, then Lordship, it is more than 5 months. If they taken the consider that 16 5 plus 22, then Lordship it is but by limitation, law of limitation, Lordship. 15 days plus 1 month here, Lordship is more than 2 months.
Yes.
So even if so that's why Lordship court in the Supreme Court the law, even if signature differ, then also.
Last question, will you pay it installmentally?
In fact, Lordship,
I'll send it to mediation.
Lordship, send the tax Lordship.
It's a not very heavy amount,
No.
1,60,000.
Lordship is the tax manager. Lordship, it is not the right time to tell the. It is let the arbiter offense. Lordship in Bhubaneswar.
Who is it?
This complaint of son Lordship. What they are doing when the students are reading Bhubaneswar Lordship, while giving their hand loan during their studies Lordship, they used to take some, give some money, and in return they take some checks Lordship. And some Lordship unutilized checks, they utilize when this person is employed somewhere. Lordship, this check has been issued in 2017, and he utilized in 2022 when he became the branch manager and he saw when his account is Lordship with amount of such amount, and he figured the amount and put Lordship on the relevant day 161,000 65,000 was in the account. So that's it, dropped 61,000. Lordship, this is a habitual offender. So Lordship,
Show me where have you said that?
Lordship, I have shown and I have given the evidence.
No, show me.
I have given evidence Lordship for this region. His brother was murdered in Bhubaneswar for this extraction of money.
Where have you said all these things?
Perhaps I have seen Lordship. I have taken. Perhaps I have taken, and I have gone back to. I could remember I am not going to. But Lordship, it is a fact, Lordship.
No, not fact, you will not help. So, show me a single sentence anywhere.
Perhaps Lordship, but I must have stated Lordship because I know the facts. If that is not there, that is my fault Lordship, but I can supplement with affidavits Lordship.
No, I am not going to. In the 138 meter, why should I go into all these things? Why I ask this because if you are saying that he is indulging in immoral conduct, then it can be declared as a immoral debt. If he is immoral debt, it is not recoverable. If you can make out a case, then I can understand. 13.
Because I have had and I have,
Yes.
but I must have been page 30, para 13 years.
Yes.
Where by petition for quantity. That is, Hon'Ble submitted the present petition is innocent and no way connected so far as the additional concern. And the thoughts implicated in the case due to conduct of son of the complainant, who has a habit of doing so and a habit of blackmailing.
I'll take it, I'll take
Innocent
this.
students.
Here, para 13 also, no? Para 13 of the petition.
And right from the state allegation. But in fact, that's his brother was murdered with this regime. Because this is a habit, all the innocent students are worship because when there's persecution studied, women is certainly of money.
Okay, I'll keep it open. Yes.
That's all. That's
Yes.
intimate there. That's
62.
the permitted, I will supplement another, in highlighting the issue later on.
Better, you highlight the paragraph which you are relying. Give it back.
Let it there, I will give another.
No, you give it. Don't burden with the papers.
Tonight I will.
You give it tomorrow.
Tomorrow.
Highlight and
Let.
only paragraph.
Only paragraph.
Yes.
Correct.
On the ground that
The present item 62 lordship, last item, sub item, that is not connected to this case, lordship.
Somebody's request, it might be obtained.
3055.
Hmm?
3055 last.
Anyway, let us see. The petitioner comes there.
Yes.
Yes.
You
You are, I think, for opposite party.
OPL lordship. In that case, last occasional lordship, none appears in that CRLMC.
Which one? Last one.
Yes, lordship.
Last one will retake, don't worry about it.
Mind.
Last matter will retake. Let the council appealing for both the parties conjointly agree that this is not.
In that case, I am for the OP. Petitioner is not.
There are 4 items in this.
The last item, you are appealing for opposite party.
Mind.
It's not related to the other matters. And you are not appealing for other matters.
No.
Oh, right. Correct. Your CRLMC 3055 of 2022. Council appealing for opposite party submit that this matter is wrongly tagged with the other bank matters. It is completely different matter and it's for B tag, obviously. B tag the matter needs after 3 months. Yes. Yes. You are appealing for opposite
I am
party?
appealing for opposite.
the 31, 343, 420, 406, now they are making a business relations. The present petitioner are giving 60 lakhs statement and the other connected LMC are there. That is under 130 of the MA. It was already dropped by the complainant. Opposite party. This is the case, section 420, 506 relating to same incident.
Yes.
And
So why don't you settle?
already settled. You have compromise also files filed before the.
Where are they? Where are they?
Could be lower. So I'm not sure
Who is the informant? Sobhagya Lakshmi.
Informant is by the Sobhagya.
Is there, he is present?
She is not.
Not really. In the code below, he has already filed and received 630 lakhs from me.
Where is that? From?
Yes, annexed to deed of compromise.
Does he say that
Yes, ma'am.
he will withdraw the case?
Yeah.
Where is that? Which part?
Okay.
1 CC case वगैरह भेजना है FIR, हाँ? Bottom body PS case number 360. 1 minute, 8 minutes. हाँ, yes. Yes, who is appealing for state?
State. If state is not party in this proceeding.
It must be party in the first. You are appealing for opposite party, and the other 2 cases are emanating from.
Dispose of
I'll dispose it up.
So, brief is.
See, there are two 138 cases,
Yes,
one
yes.
420 arising out of the same transaction. In 138 cases, they have settled with the suit and they filed a deed of settlement. Okay, deed of compromise. In the compromise deed, it is specifically written that the complainant will drop for the case 360. Badambadi, Badambadi PS case 360. Okay. Then I'll cause it.
Yes, your lordship.
And
After
the
compromise deed, let's see that person got the bail in court below.
obviously, bail is the right first thing. And second two matters you will
Simply dispose of it.
yes.
Entire.
I'll say that in view of the settlement, the matter has already been compromised and accordingly disposed. First liquor. At the instance of opposite party number 2, FIR number 4. Petitioner. The petitioners are also not there. John, what about the other? The petitioner, the party, in regard to the litigation with the fire, there were two CC cases. Which are the CC cases? Two. There are two. Here 138 cases. 138 cases being one CC case number 1655 of 2019 and one CC case number 2498 of 2019. Three cases. And three cases. And one CC case number 2497 of 2019 has also been initiated by the opposite party against the petitioner and opposite party entered into a composite settlement. In terms of the composite settlement, and they have reduced down the settlement to a compromise, deed of compromise of the agreement dated 21 December 2022, which has been placed before this court, which has been placed in, which has been filed as an except to this petition. The terms of settlement has already been is enumerated as under the para 2 root. Para para 15 row 1 para 15 row 1 is para 16 row 4
Page 17, para 4. 4 and 5. Page 17, 16, 17.
4, 5, 6. What about the 6 you have written? Shall withdraw? Acha, 4, 5, 6. 4, 5, para 16. Page 16. Page 16, 17. Okay, para 4, 5, 6. So, in persons to the aforementioned settlement terms, these are the three CRLMC number 3052/2022, 3053/2022, and 3055/2022. Recent for play along with the present matter has been agreed to be withdrawn. Has been agreed to be withdrawn. And the petitioner who is appealing? Petitioner number 1. Petitioner number 1 is present in the court today, whereas the other two petitioners, you just move an application for exemption. Other two petitioners are not present. On behalf of the petitioner number 2 and 3, an application for exemption from personal appearances from the court has been filed. For the reasons stated in the application, the same is allowed. The opposite petitioner number 1 is being represented by the party and identified What about the opposite party number 2?
Who is the present informant?
I know that he is not present. Opposite party number 2 or is also not present in the court. However, she is represented by the learned counsel. Have you filed the wakalatnama?
Yes, see. Name is there.
You have filed the wakalatnama in this case?
Connected case, we are also-
No, I am talking about in this case.
Nobody is in
Then
reference.
Connected cases.
I have give dictation. I'll put it tomorrow. Okay?
That's it.
I'll put it tomorrow. Either she should appear, file wakalat.
That's if she may appear through.
The paragraph. Since the parties have already settled the dispute and disputed amount has already been paid. Already been paid to the opposite party and which has been endorsed by the council appearing on her behalf. There is no legal possibility to the file in terms of the component, in terms of the component. So please for the bill, submits that to the transaction is arising out of business dealing and the parties have settled the dispute and filed the affidavit for the court. I filed the compromise deed before the court. Therefore, there is no legal regarding that. Yeah, that is what it is. This is order type of you and matter I simply list tomorrow. And get that exemption out. And the order I have dictated. In tomorrow's date, I'll file wakalat. Yes. Tomorrow. आज खाली अर्जेंट कर दो काली पे कर दो टाइप कर दो ओके नींद अच्छा और दिटा तीनटा मैटर जो अछि अलगा अलग कर दो इन डिटेल और पास जो तीनटा अछि सर डिटेल और पास in 318 of 2023 and in view of the settlement terms the petition distribution of room the counsel for petition seeks to withdraw this petition. Okay, same order. Third,
63. May I place a lot? I'm going to virtual model. I'm for the information. Was it party number
Mr. Tripathi, in the complaint case, in the settlement, you have written 3 matters, 138 matters.
Yeah,
But there are 2 CRLMC.
One CLMC number 3051, 3053, and another is 305.
Where is 51 is not listed?
5.1 already. That is item number 1 with a case.
It's already disposed.
Yes,
Okay.
yes.
Therefore, this is the confusion.
Okay.
Not.
It is the last thing. Yes. Yes.
This case was said to for the mediation. The mediation for marriage. Here, Cognizance is dated. Whether the office punishable under section 41 to 94, 506. Before
Your Lordship, pardon to intervene, Your Lordship. Lordship, due to network issues,
Yes.
it is not audible, Your Lordship.
Yes. You are appearing for?
For opposite party number 2, Your Lordship.
Okay. What do you want?
Lordship, the voice is not audible of the other side, Your Lordship.
Lordship had the matter. You Lordship are absent. After that,
Yes, immediately.
ସେ ତାଙ୍କର ତ voice ଠିକ ରହୁଛି ଆଉ କଣ ଶୁଣୁଛୁ?
She may be having some problem. You also may face some probably young lady. When can you come, madam?
Lordship, because of the weather, I guess there is a network issue.
Senior counsels are here. There is no weather problem. You have a weather problem.
I sincerely apologize, Your Lordship, but admittedly, there is a issue in.
See, the
Audio
entry
equipment.
order is operating in against you.
I consider your lordship. Any short date may kindly be fixed.
You give me, tell me the date. Tell me the. 30th.
Obliged, your lordship.
But on that day, please come, huh?
Yes, your lordship. I will physically appear on that day.
Entry mode to continue.
Grateful, your lordship.
See, decency is, see, other lawyers are waiting.
Yes,
It
your
is 4
lordship.
o'clock. You should have told them.
I apologize, your lordship. I apologize.
You should have told them, because see, this is minimum decency expected from, junior counsel towards the senior counsel.
Yes, your lordship. I sincerely apologize to the
In
parties.
future, if you want to adjournment, you please tell the other side, okay? Okay.
Your lordship. Grateful. your lordship.
My lord, was pleased to adjourn a particular case, my lord, where mediation has succeeded. And they are the only counsel was the government counsel, because they had gone for measurement, and measurement could not be allowed was not allowed by the petitioner, for which
You
a
can
case.
dispose it upon them.
My lord, it can be disposed of.
Mediation
It is successful. Why?
My lord. Can be
54.
disposed of with the line of the mediation.
54 allow
Right.
in view of mediation report. Mediation successful, they participated on 54. Now is there, no?
No.
Repeat.
77.
Mediation successful, first we do what wide order mediation also. Party disposed of in and both of them undertake to comply with terms of obligations, comply the obligations going their part of the obligation flowing from regarding the two terms of settlement, whereas the party obligation report and undertaking the report. 54.
64 minutes, notice has been sufficient, but no one is appearing on behalf of the opposite party minutes.
Please, notice is sufficient. Rakesh Malik.
Let's wish to hear me, I can.
Who entered it? These two judges. So, no.
Or a short date may be fixed.
Party so I have already entered agreement, but not like yes for the opposite party number 2 today. Hence leads the matter in the interest of justice.
Lots of short date may kindly be.
Entry mode to continue. Entry mode to continue. Yes.
Lots is fixing it to
On the, yes, entry mode. Yes.
let's grant last chance, Milos, because on the last date also.
Many a time you also take entry mode.
I bar.
65% can be taken off the matter next week.
Putting for the opposite partner.
Petitioner.
And for the opposite partner to your lordship. Lordship may kindly glance at the order dated 13/3/2025.
Yes. What is your answer to that?
You are not seniorly arbitration attorney.
No,
You
you have
see
to pay the
LLC
wages to the, that is what the specific question put to you.
Last
Thereafter you took adjournment. Now again you are asking adjournment. See, what I have written, just read it out.
I'm working on
Read
it, but
it
the
out.
last chance was given
Huh.
to
If you
make
want
do of
give
the
back
payment of wages, and that is entry mode is there, that can be vacated. Why I say that, Malos? Because of that a civil trial has been said, Malos. Payment of wages act, Malos, it's a civil trial.
entry mode is not there. There, Sir, the matter was heard extensively on 13/3/2025 and following order. Thereafter, the matter was listed on 21/3/2025 and on the request, matter was adjourned in earlier past 20. On behalf of the petitioner, there has been in view of who the order dated 13/3/2025, there is no impact on the time of court to use the interim order part earlier. Is liable to be recognized accordingly. Interim order, very interim order.
And then starting in Russia.
Where is, accordingly, the interim errand made on ODA will be absolutely. The receipt is withdrawn.
Order date 22/2024 may kindly be seen.
22
2024. Para 4, your lordship.
2020.
20th February 2024.
Needs the matter for this. I have withdrawn that. Yes.
Malas, grateful.
Yes.
66. 66. This is for quasi. My lord, the husband and in-laws are before your lordship. My lord, the allegation made as against the all 307 has not been made out, so no charge sheet has been filed. During the pendency of this case, your lordship was pleased to direct for mediation. In the mediation, the husband is a schizophrenic.
7 days, okay, short. Learning counsel for the complaint officer, television, it founded on dated at the court and directed to the accused through his learning counsel.
We will not place before the court the order.
Yes, I have played. He told that it has not been extended. Because thereafter the case was not.
Now, immediately is issued.
Yes, that has been issued. Sir Lamsi and produced the defense evidence. It has been posted for defense evidence matter. For that reason, your lordship has passed an interim order directing to that interim order will continue passed in 6/9 Sierra Lamsi number 2691 of 2022. If that case is not taken up, then it will not be possible for disposal of the entire case matter.
That matter is not disposed of.
No, that is pending matter. While I have given the entire certified copy, court disbelieves this.
Release the matter along with the CRLMC number 2691
of
2022. 2020. Interim order.
I have, in that case, I have given an offer.
What is check amount?
Check amount is my lord. 1 crore somewhat. Actually, there is a transaction of 30 to 35 lakhs. What? Sorry, my lord.
Paid
1 crore total transaction.
68.
In state, the mediation report has come. In fact, the mediation has been successful.
Successful.
Yes. And he has started paying also.
Your lordship, we posted to after 10/5 because the next date of mediation is on that day and the remaining amount is also to be paid on that date.
Okay, 11th.
11th.
12th, huh? 12th.
12th.
Mediation process is going on. The matter is fixed. People mediation center on 10th.
Interim order to continue.
Interim order to continue. Many matters are being
Yes.
settled in the mediation.
Yes, sir.
Your lordship heard it extensively, then found out the check amount, then said you go for mediation.
Many matters are being settled.
At our expense.
69.
At the expense of trial lawyers.
I was giving an offer to my friend Jana, Mrs. Jana.
But in any case, dispute has to be resolved.
I
Either
told,
through you
Lord,
or-
I told her
Hmm.
that instead of paying upfront 1 crore and 20, she can ask her client. 50% of that amount can be paid to my friend Mr. Mahapatra, he will get the back with 25% in installments, I'll get the back.
Yes.
So here the state was to file some objection, my lords.
Have you filed?
The matter has been compromised between the parties. Hello, your lordship kindly see. The informant has filed an affidavit. And the informant father, the statement made by the informant father in the 161 statement and the affidavit statement made in the affidavit. The lordship kindly see the paragraph. The affair in the present case was filed being instigated by some villagers who are inimical to the petitioners.
You are supposed to file reply. Are you going to file reply or not?
Yes, yes.
It is a case of 302, 304.
Yes,
304B, 306.
And 306 is there.
306. So therefore, the state has to respond. It is a matter of settlement. Okay, file it. Entry mode to continue. Take me 5 minutes. After 4-5 minutes, 4 weeks. 4 weeks. 70.
70, Lordship, I'm appearing on behalf of Miss AKB. She is unwell today, Lordship, so I'm seeking for an adjournment.
Please, Your Lordship. 71 is a default date 2022, my lord. The petitioner remanded to judicial custody, Your Lordship. Thereafter, my lord, after filing of this CRLMC application, my lord, on 21st May 2024, the IO submitted the charge sheet, Your Lordship.
Yes.
Now, my lord, I am covered with the judgment of Honorable Justice Sankar Mishra, sir, coordinate bench of this Honorable Court, my lord. That is
Don't take the name of a judge.
coordinate bench.
Yes. Don't tell the name. It's not necessary. If all the courts are high courts only. Show me the order judgment.
My lord, that is tagged with another memo. Page number starts from page number 13. The relevant paragraph starts from page number 16. Memo, Your Lordship.
Memo.
Why a memo? I have submitted the case law, Your Lordship.
Ritu Chavaria.
Ritu Chavaria and Ritu Chavaria is a judgment of Honorable Supreme Court. And
I got it. Halluri
Chakravarti is the judgment of this Honorable Court.
Yes. Which para?
Paragraph number 6, 7, and 8.
6, 7, huh? 6, yes.
My lord. After 180 days, my lord, within 180 days, the charge sheet has not submitted. On 181 days, the present petitioner not produced before the court below, and the learned court below also not informed the indefeasible right to the petitioner. The 3 grounds are there.
Yes. The preliminary charge sheet when you filed.
Yes.
That time he was not there. Preliminary charge sheet is not filed against him.
But in the preliminary charge sheet, there his name was there that he is a purchaser and a financer.
But the charge sheet is not filed against him. He says that since in the preliminary charge sheet is not filed against me,
yes,
and the supplementary
But
charge sheet
keeping
is
the
filed beyond
investigation
the.
open.
So therefore,
Keeping the investigation open.
do you have
One-
any judgment that the show me the judgment?
The paragraph 23.
The preliminary charge sheet you have
Yes,
not
yes.
taken his name.
Paragraph 20.
Para? Yes, para?
23.
Yes.
The benefit of a provider
appended to subsection 2 of the 167 of the code will be available to the offender only when the charge sheet is not filed and the investigation is kept pending against him. Once, however, a charge sheet is filed, the said right seated. It may be noted that a right of the investigation.
No, the first two lines read it. He's covered by that.
Yes,
First two lines, yes.
It may be noted that a right of the investigator to play the further investigation in term of subsection 8, section 173 is not taken away only because charge sheet is filed under subsection 2 thereof against the accused. Though the ordinarily all documents relied upon by the prosecution should accompany the charge sheet, nonetheless, for some reasons, if all the documents are not filed along with the charge sheet, that regime by itself would not invalidate or vitiate the charge. It is also well settled that the court takes cognizance of the offence and not the offence. Once from the material produced along with the charge sheet, the court is satisfied about the commission of an offence and takes cognizance of the offence allegedly committed by the accused. It is immaterial whether the further investigation in terms of section 173(8) is pending or not. Tendency of further investigation was the other accused or for production of some documents not available at the time of filing charge sheet would neither vitiate the charge sheet nor would it entitle the accused to claim right to get the default bail on the ground that the charge sheet was an incomplete charge sheet or that charge sheet was not filed in terms of 173(2).
No, his case is some little bit different.
Well,
The first two line reading.
But that first two line, your lordship,
The other see,
no
the
charge
accused
sheet
against
was filed against the petitioner.
the other accused persons
Yes.
against whom you have filed a preliminary charge sheet,
Yes.
they can't avail 167(2) saying that see the charge sheet is incomplete.
Yes.
But what will happen to the accused against whom you have not filed charge sheet at all?
But the
first two
investigation
lines,
kept open.
maybe that's the first two lines. Just see the benefit of the proviso
Yes,
appended to subsection 2 of section 167 of code would be available to the offender
Yes, sir.
only when the charge sheet is not filed and the investigation is kept pending against him.
Against it, what here in the preliminary charge sheet,
But
his name.
Preliminary, against him, the investigation was kept open.
Yes.
And he is remaining in the custody beyond 180 days. Then
Yet that in other case he was in custody. In other
no, my lord. No,
in this
no,
case.
your lordship. In
I'm
this
talking
case
about in
only.
this case. I'm not interested in credentials
Yes.
at all. He may be involved in 1,000 cases. How does it
Yes.
make difference? His statutory benefit has to be given, That's all. Credentials are not, antecedents are not
your
relevant.
lordships, even when the investigation is kept open, just below in that.
That's right.
paragraph-
Investigation is kept open for this accused.
Yes, my lord. So
Then,
the charge sheet filed.
So therefore, this judgment is going against you.
Lordship, last.
First two lines.
Last.
No, see, the last lines are relatable to the accused against whom you have filed charge sheet.
Yes.
They can't take benefit saying that it is not a conclusive charge sheet. So 167(2) benefit will not be given to them.
Even again, I am reading. Though ordinarily all documents relied upon the prosecution should accompany the charge sheet, nonetheless, for some reasons, if all the documents are not filed along the charge sheet, the regime by itself would not invalidate or vitiate the charge.
Okay, now in the preliminary charge sheet, show me his complicity. Have you discussed his complicity?
In preliminary charge sheet.
Show me the preliminary charge sheet.
Yes, yes. And
That starts from page number 51, your lordship.
here
Sonu
54, your lordship.
Hmm.
54.
54.
When the cognizance was taken?
Cognizance was taken.
Cognizance also not taken against me, man.
Obviously.
8/8/2022.
Yes. Sonu Moto.
Sonu Moto. One page 145 order. This
in trial court, he had filed the same 167(2) petition, which was rejected on the ground that in charge sheet, his name has been mentioned as financial.
That is impugn order, but that rejected on the ground of criminal antecedent. The conclusion of that impugn order.
There is a 145 page. Page 145.
145.
Yes, ma'am.
Yes.
The petitioner under section 167(2) CRPC filed on behalf of the Sonimata to release him default bail. And the finding perused 146 man. Perused the case record, it appears on 7/8/2022 IO submitted preliminary charge sheet under section so and so against the so and so petitioner. On 7/8/2022 on prayer of the IO, the petitioner was remanded in this case, and in the meanwhile, statutory period has already been elapsed, but IO has not filed any final charge sheet. The charge sheet which was submitted by the IO is incomplete. It is a settled proposition of law that the right to get default bail is an indefeasible right, and this right must be exercised by offering to furnish bail. If charge sheet is not filed and the right of default bail has ripened into status of indivisible, it cannot be subject to prosecution on any pretext. The accused petitioner is in jail custody since 10/6/2022, and in his application, he has also expressed willingness to furnish bail bond. So and so decision has been cited. As a matter of fact, it is in the present case, IO has submitted preliminary charge sheet against the accused on 7/8/2022, keeping the investigation open as the present petitioner was not remanded in this case. The record reveals that on the prayer of IO, the accused petitioner was remanded on this case on 7/8/2022, and since then he is in jail custody. It
So
appears.
then in this case, he was remanded first time on 17/8/2022.
8/2020.
Yes, Mr. Sahu.
My lord, on
In this
third.
case, you were never remanded. You were in custody in some other case.
Yes, yes.
My lord, what happened, my lord? In some other case, IO, and this case, IO also one officer, my lord.
Oh, that's a different story. In this
Your
case,
lordship.
when you came into custody,
My lord,
that is on 17/8/2022.
IO moved application on 3rd August 2022, my lord.
You may be there in custody in some other case, but in this case, when you were remanded, you were remanded first time on 17/8/2022.
Your lordship, page number 72 may kindly peruse. That is the order of the learned court below. The impugn order and order of the learned court below are contrary, my lord. He said.
That is a different story. I just see the preliminary charge sheet also. I just looked into preliminary charge sheet. Last two lines of preliminary charge sheet. Just see.
My lord.
No. Come to page 54.
My lord.
Last line. Under the above fact and circumstances, as some action are yet to be complied.
My lord.
That is to receive the acceptance of the remand report of accused Sonu Moto from the Honorable Court, obtaining so and so. And that's what he obtained, and he saw that you have been remanded to the custody on 17/8/2022. So therefore, 167 benefit cannot be given to you.
Your lordship, I will satisfy, my lord. The complainant and the IO of the both the case are same, and the learned court below is the same, my lord. The
You
IO.
simply tell me when you were taken into custody in this case.
The order sheet, page number 77, may kindly have a glance. Your lord. That is the order certified copy of.
State council is to file a specific affidavit stating specifically specified as to which day the present petitioner has been taken into custody in relation to PS case number.
Yes, case number.
Yes, Sundarabad down PS case number 224 of 2020. Please the matter. You file an affidavit.
Yes.
When he was taken into custody.
And who is the IO of both the cases, my lord?
My
lord, he is the IO, my lord. He said, I don't know about the accused where he is. he forwarded.
Whoever may be the IO, the same IO might be investigating two cases. I am
My lord-
interested in the date of custody.
My
Yes.
lord, the same IO, what I am submitting your office 30-second, the same IO forwarding the accused in that case and saying, I don't know about the accused, where he is in custody.
Let him file the affidavit
Thereafter he filed.
along with
I
the
will
remand.
submit the remand application before.
Yes, next. 72.
Grateful, Your Honor.
Your Lordship, my lord. On their application, last occasion, this was directed to service notice through IIC town, Kensington PS on the complainant opposite part number 2, my lord. Your notice has been issued to court, he has not appeared. my
Yes.
lord. Notice to
Through IIC Kyonjar, service on opposite party number. What is the report?
Yes.
Farmer.
Yes, we received. On 20 January 2025. This was notice was issued to that informant.
That's the report.
Yes.
The person to the order dated 9/1/2025. By the order dated 9/1/2025, this court has directed the IIC Kyonjar to county to serve opposite party number 2. What is the report dated?
Report dated 20 January 2025.
20 January 2025, the IIC Kyonjar police station has placed on police report entry stating that the service of the notice or the notice has been served upon the opposite party number 2. However, none has entered appearance none has entered appearance on behalf of opposite party number 2 in the interest of justice. This matter also entry on to 20.
Entry order.
Entry on 20.
73.
Yeah, please. My lord, order dated 26/2019, Cognizance order of the Lawrence Trial Court has been challenged, my lord.
Yes. What happened to mediation?
Mediation failed, my lord.
Okay. Who is appealing for the opposite side?
Mohan.
Who is there? The matter was referred to mediation. Center, and I will author. None appears to the department or even second call for the interest of the decision. 74.
Published.
The proceeding on section 138 of the NIS, my lord.
We are appealing?
Of the complainant.
What are you?
I say, my lord, here the check of the corporation bank was issued, my lord. On the date, the check, the corporation bank has already, along with the other two banks, they have merged with the Union Bank of India, my lord. Union Bank.
What is it?
And the similar matters have been disposed of that the 202 inquiry has not been made. My lord has directed the trial court to take in other cases. Some branch of complaint cases has been filed by the present complainant, my lord. And my lord has remanded the court and to take this summons and they direct the trial court quashing the cognizance order and directing the trial court to take a statement of the complaint under section 212 CRPC
Yes.
and conclude the trial within a period of 3 months.
I have another point, my lord. I'm on the proceeding. That is my second point. What my lord friend said, that is my second point. Now my humble submission, my lord, that the check, the banks, the check of the corporation bank was issued. Corporation Bank, Axis Bank, and another bank, they merged with Union Bank. One bank came, Union Bank. On the date of issuance of the check, the bank has already merged with the Union Bank, my lord. Therefore, my lord, my respectful submission is that no case on section when the check was invalid, my lord, on the date of its issuance, and also on the date of its presentation in the bank. Therefore, the case on section 138 of the NIA is not maintainable. My lord,
show me the amalgamation.
My lord,
Show me the amalgamation agreement.
Yes, paragraph,
Show me.
page, annex 1, my lord.
Annex 1 to
Annex 1. I will make it.
notification. Yes.
2.
Yes.
2.
Hmm.
Bank means transfer bank. Then E minor. Transfer bank means Union Bank of India. Transfer bank means Andhra Bank. Transfer bank means Corporation Bank. Those three banks they work with. One bank.
What will happen to the instruments issued before during that transition period?
That was
all will be invalid.
For a particular then those were my lord I have given it.
Show me these are the definition after the amalgamation is taken.
Yes, my lord.
During transit, what will happen?
Yes, my lord.
Show me that.
My lord.
And
My
the
lord,
notification
my
is
lord, my lord, may kindly
complete
see-
notification. Saving and EA clause. Show me.
My lord, may kindly see paragraph 6 of the document which I have given, my lord.
This one.
You.
Yes.
Paragraph 6. After hearing the rival submission of the counsel for the parties and peruse the record, it is clear that the Allahabad Bank and had merged into the Indian Bank on 1/4/2020. Thereafter, a wide circular was made by the Indian Bank in newspapers mentioning the fact that all the checks issued by Allahabad Bank can be exchanged with the checks of Indian Bank by 13/9/2021.
And the check
The checks from Allahabad Bank will be honored by 13/9/2021.
But in your case, where are these
The
notices?
same thing happened, my lord.
No. So show me that. Show me that there was a publication and all. Unless you show that you want to cover it. Show me that.
My lord, I pray for.
If there is a valid publication, then you may have a case.
My lord, my lord. I pray to explain.
Yes. Yes. Roll over all the matters.
These of the
I have to extend.
Item 8.
All the matter will be roll over for tomorrow.
that matter, I press tomorrow.
Tomorrow.